John Day.
Councilwoman Galloway. Galloway. Councilwoman Galloway. Hello, everyone.
Thank you. You ready, Janelle?
Yes, 5 here at the moment.
Okay, let's wait a few minutes.
Okay.
I know Mr. Guerrero will not be able to attend.
Okay. Okay, you got everybody present then.
Great. Thank you. Okay, well, I'd like to say welcome to the Flint City Council meeting on Thursday, December 3rd, 2020 at 5:31 p.m. This is the second meeting recessed from the initial meeting date of November 23rd. The first meeting was recessed to November 30th. This is an electronic public meeting. So at this time, I would like to return to order of this meeting, starting with roll call.
Mr. Mays,
Present.
Mr. Davis,
Present.
Ms. Fields,
Present.
Ms. Winfrey Carter,
Present.
Mr. Winfrey,
Present.
Ms. Galloway,
Present.
Mr. Griggs,
Present.
Ms. Worthing.
Present.
Ready to move on?
Oh, I'm sorry. Yes, you have 8 here.
Thank you. Okay, that brings us to the member remote announcement. Pursuant to the newly revised Open Meetings Act, each council member shall state that they are attending the meeting remotely and shall state where he or she is physically located, county or city and state. There is member contact information on the agenda for all council members. Now I'll read from...
Oh, did you want me to get the member announcements, where they're from?
Yes, please.
Mr. Mays? This is the remote announcement of where you're calling from, that you're remote and where you're calling from. He may have dropped.
Okay, well, go ahead with Mr. Davis and come back around to Mr. Mays.
Okay, Mr. Davis?
Yes, this is Councilman Maurice D. Davis. I'm attending this meeting remotely in Genesee County, located in Flint, Michigan.
Ms. Fields?
This is Kate Fields, 4th Ward Councilperson. I'm attending the meeting remotely from Flint, Michigan.
Ms. Winfrey Carter?
Good evening. This is Councilwoman Jerry Winfrey Carter, 5th Ward. I'm attending this meeting remotely, Flint, Michigan, Genesee County.
Mr. Winfrey?
This is 6th Ward Councilman Herbert Winfrey attending remotely from Flint, Michigan, Genesee County.
Ms. Galloway?
This is 7th Ward City Council Person Monica Galloway, attending this meeting remotely from Flint, Michigan.
Mr. Griggs?
Attending the meeting remotely from Flint, Michigan in Genesee County.
Ms. Worthing?
I'm attending the meeting remotely in Flint, Michigan, Genesee County.
Mr. Mays? I still don't see him on the line. I don't know what happened.
Okay. Well, we'll just proceed. I'm sure he'll come on when he's able to. Now I'm going to read procedures on conducting electronic public meetings. All boards and commissions must adhere to all laws established under the Michigan compiled laws and in accordance with the revisions to the Open Meetings Act adopted in Senate Bill 1108 as passed on October 13th, 2020 and signed into law on October 16th, 2020. Now I'm going to read the Disorderly Person City Code subsection. Any person that persists in disrupting this meeting will be in violation of Flint City Code Section 31-10, disorderly conduct, assault and battery, and disorderly persons, and will be subject to arrest for a misdemeanor. Any person who prevents the peaceful and orderly conduct of any meeting will be given one warning. If they persist in disrupting the meeting, that individual will be subject to arrest. Violators shall be removed from meetings. Now that brings us to the discussion item. I have been asked to say as chair to suggest that there are 10-minute rounds, 10 minutes per council member, starting with council members who have not yet had a chance to speak and or speak to the attorneys, and that speakers not be interrupted, please. I've also been asked by the city attorney, she would like to introduce all of the attorneys that are online. Ms. Wheeler?
Point of order.
What's your point of order?
Our point of information, Council President. Doesn't that require a vote of the members? Because it's not in our council rules, so what are you using as the basis for this request?
Ms. Galloway, I think it's a choice of council, but if someone would like to make that motion, I'll certainly entertain that motion.
Madam Chair?
Mr. Davis?
I'd like to make a motion that we have 10 minutes per round, and after that, the maximum 10 minutes a round, and after every council person has spoke, that we keep going around till everybody is satisfied, and also no disrupting the attorney or administration. At no time else you could be ruled out of order. I make a motion. So moved.
The motion's been made. Is there a second?
Madam President?
Mr. Winfrey?
Yeah, I second that motion.
Motion's been made and seconded. Is there any discussion?
Madam President.
Yeah.
Ms. Galloway?
So, through you to Councilman Davis and Councilman Winfrey. So, are we saying that a yes on this vote, if a council person interrupts at any time, they are going to be removed from the meeting, no warnings, no ifs, ands, or buts, if there's 5 votes on this vote? That's my question first before I proceed.
Madam Chair?
Mr. Davis?
Thank you for indulging. To my colleague, Councilwoman Galloway, what it is this: we just want to keep order and maintain respect as we would want them to respect our question, because we want to ask whatever, so we will, and have plenty of time to ask thoroughly. So just be, respectful of their response, and then we just have dialogue back and forth like we did before we recessed the meeting. No more, no less. But we must at all times maintain a discourse of respect. Thank you.
Madam
Thank
Chair.
you, Mr. Davis.
Ms.
Galloway?
Wait a minute. Councilman Davis did not answer my specific question. Part of his motion was that if, in fact, any council person interrupts any person on the administration or the lawyers or anyone, that person will be removed from the meeting. That's what his motion was.
And so that means no warning or anything. Anybody that interrupts at any time, wait a minute.
Just a moment, Mr. Davis. Wait until Ms. Galloway is finished speaking, and then I will let you respond.
Thank you. I just want to make sure that's the way the motion read. And so that's his motion that he made. That's the motion that Councilman Winfrey seconded. And I just want to make sure that before I cast a vote, that the way that it was worded is the way that we are saying will happen. And so I just want to clear yes or no, or reading back the motion, and then we'll go from there, Madam Fields. And I haven't, President Fields, released my time. These are simply questions of the motion maker and the motion seconder. Very specific, yes or no, was that the intent, because that's what was made.
Madam President?
Mr. Davis, would you like to respond?
I'll respond. Yes. No, Councilwoman Galloway. We want to show latitude and respect. There will be normal warnings as we would go. And even the chairperson got latitude. We need to get to the bottom of what's going on with this water. And we don't want to get bogged down, as Councilman Winfrey always suggests. We want to ask these questions for the community without us being in argumentative discourse. That's all. Yes, you would be normally warned, and hopefully it'd be a lot of latitude that we could get to the bottom. Thank you. I hope that answered.
Madam President,
Davis, just a moment. Ms. Galloway, would you like the floor back to complete your discussion?
Through you to the record keeper, can you please read the motion that was made and seconded for the record, please?
What I got was that there would be there'd be 10 minutes maximum per round, and they'll keep going with round and round, and no interrupting speakers. If you said something about people getting kicked out, I didn't catch that.
So there's no, if you interrupt, you get kicked out of the meeting. That's not part of the motion?
That's not, I didn't hear that, no.
So thank you. Then I'm fine. Thank you, Madam Chair. I relinquish the time.
Madam President.
Would anyone else like, Mr. Mays, welcome back.
Yeah, I dropped the call, and I'm here to tell you, I'm concerned about it because the motion was you out of order. When you're out of order, you're removed from a meeting, and so that concerns me. He's cleared it up with the verbal, but I think that should go for the chair too, because the chair has had a habit of interrupting. All right, so I'm concerned about that based upon the atmosphere I've been in. This is an important matter. People need to relax, and some of them attorneys waste his time assuming we don't know the basics of what's going on. Maybe some of us don't. But when I get the floor, and if I got 10 minutes, we don't know how these rounds will go. We don't know if the attorney will speak for 10 minutes and how we chop up hours. When I ask an attorney a question, I need that specific answer with my time. I don't like for people to be telling me all kind of stuff different from what I'm asking, and then I don't like for the chair and others on the council to say just let them speak. It wastes a lot of time with some council people. We want specific answers to the questions, and all of that come into play. So can we use point of order when they don't answer our question to interrupt? We've got to have some way to deal with our 10 minutes. We can't do like when the mayor came, I called him up. I know how this discussion item got on here. And I'm telling you, we got to be able to control our forum. I looked at Giuliani and them in Lansing. I looked at Senate hearings. We are the legislative body. We should be able to ask specific questions and not get roundabout. And if we do, you still got to honor a point of order. We've got order and decorum. Let's just use it properly and be cordial to each and everybody.
Would anyone else care to discuss this?
Madam Chair?
Who is that? Mr. Davis?
Madam Chair? Thank you.
Could you let everyone who has not had, Mr. Davis, let's, on discussion, anyone who has not yet had discussion on this item like to speak? Anyone who's not had discussion? Well, I'd like to say something for my first round. I'd like to say, first of all, Janelle, I wrote down this motion as it was made, and the only piece you missed was that the discussion would start with those members who have not yet had an opportunity to speak. So you forgot that in the motion, and I would like to say to Mr. Mays...
Point of order.
What is your point of order?
Madam Chair, you're implementing what you requested, and that is not what the motion maker said. That's my point of order.
Well, Ms. Galloway, you are wrong on that. That is what the motion maker said. The motion maker did include that it would start with those who have not had a chance to speak. She may have missed that, but I certainly heard that.
But
your point of order is denied because that is what I heard.
I appeal the rule of the chair.
Okay, there's an appeal to the ruling of the chair. Is there a second? Mr. Davis?
I second.
It's been seconded. Okay, I heard Mr. Davis say that they would start, that the rounds would start with those who have not yet had an opportunity, members who have not had an opportunity to speak. So even though Janelle didn't have that in her notes, that is what I heard. Who else would like to discuss the appeal?
Madam President, Councilwoman Monica Galloway.
Ms. Galloway.
So Councilwoman Fields, President, Madam Chair, Fields. He did not say that. You said that, and you came in setting a precedent, and you said that members that have not spoken should speak. The attorney has asked this, and so. And then at that point, you moved on to call on the attorney, at which time I did a point of order or a point of whatever, point of information, and asked, isn't that normally something that will be done by the body, and or what is the policy or procedures for that? When Councilman Davis made his motion, he did not proceed with those that have not spoken, because it's interesting that you're saying that because you and the ones that didn't speak left the meeting. But he didn't say that, and I'm hoping that he'll clarify that since he actually supported this appeal. I know what you said you heard, but I also thought I heard him say that if you interrupted, you would be ruled out of order and removed from the meeting. And so I said that to say that it sounds like we both can mishear what we thought we heard, and the fact that the record keeper didn't have my piece, but you're so willing to make sure that she knows that she missed what you thought you heard. And so I didn't hear that, and I'm hoping that my colleagues will support my appeal, and I will be voting no on the ruling of the chair.
Would anyone else like to speak on the appeal?
Yes,
Madam Chair.
First, Mr. Davis.
Thank you for indulging.
And then Ms. Worthing.
My colleague, Councilwoman Galloway, absolutely correct. I don't remember stating that in the motion at all. I just want clarity that we can move forward in this meeting in a timely fashion and get a whole lot of information in right now so the community can feel comfortable with whatever the outcome is. Thank you.
Thank you, Mr. Davis. Ms. Worthing?
I really wish a point of information would have been made instead of this appeal so that we could have just heard from Mr. Davis without all this nonsense. Also, why shouldn't the people that haven't asked questions go first? It's not the fact that we left, because I'm not staying until 2 a.m. You know, I have a life. Apparently some don't. And so they stay till 2 a.m. screaming and yelling at attorneys. So what's wrong with letting those who want to go first go, haven't talked, go first? I mean, why do we have to be so combative and rude and mean about everything? It's tiring. Thank you.
Point of order.
Who's calling that point of order?
Councilman Davis. Let's
Councilman Davis.
Attack and innuendos, because this is too early in the meeting for that. Let's stick to what's on the table. Thank you very much.
Madam President.
Mr. Mays.
Yeah, Madam President. what Mr. Davis is saying and what we're trying to say is absolutely right. This is an important matter, and Ms. Worthing, this is how you take care of business in an orderly fashion. That's how Robert's Rules and Council Rules was designed, for points of orders, points of information. It's not nonsense. It's a way to try to conduct business when there's multiple people. And based upon the history of this council, we need to know that we can say point of information if a lawyer say a term that we need a quick clarification. We shouldn't have to sit like dummies when we've been here. I've been here for 7 years, going on 8. Y'all been here for 3, going on 4. We know how to conduct meetings. We just got to have a nicer spirit, a more Christian spirit, a more golden rule spirit. Do and talk unto others as you would like them to talk unto you. You won't want to be called 6th graders and 3rd graders and negatory stuff. That's what gets me going. I can talk just as good as the others, and I know how people set up rules and hear stuff and know rules that they don't hear. I'll be voting no on this one, and I'm telling you, if it takes a little bit of this to get started and go smooth, then do it. But then have courtesy all along the way. And let's just get this business done. There's probably a lot of people listening really want to know the details of this settlement or proposed settlement. And so I don't reward people for absenteeism, and they shouldn't be rewarded. We'll be all right. I wouldn't care if I spoke last and the meeting ended and it recessed again. When I got quality questions, this ain't a 10-minute discussion, and I'll be listening to the people who speak first. I don't want to speak first. So if it's talking about me, I'm knowledgeable on some details. I want to hear how knowledgeable my colleagues are. I can tell from the questions they ask. I can tell if they're at the input stages of understanding, the medium stages, or they really getting it. So it's going to be an interesting thing for me. And Ms. Fields, counsel, don't just be scared to not go 10 minutes. Don't be scared to let people finish up, Ms. Fields. And let's just go around and let colleagues enlighten themselves, get information, and hopefully it'll disseminate properly to the community. So we know everybody's personality. So let's just see what we can do here today. Thank you.
Would anyone else like to have discussion on this appeal? Anyone else? Well, then I'd like to finish by saying I did hear Mr. Davis say that. He says he did not, okay, that would be included. And I thought basically when he said it, it should be included because it's only fair to let those who have not had a turn have a turn. This is not a council of 1 or 2. This is a council of 9 people, and everyone should be able to have fair and equal time. And I let Mr. Mays go far afield in his discussion of the appeal. He spoke on many things that had nothing to do with this appeal, but I gave him latitude and let him do that. But I would like to respond to one thing he said and that means the chair can't interrupt. I will tell you that the chair has a right to chair, and I will be chairing according to the rules as I understand them and Robert's rules. And if anyone is disruptive or disorderly, they will receive a warning. And if they continue, they will be removed from the meeting.
Point of information.
What's your point of information, Mr. Mays?
Ms. Fields, could you have really said that without taking a shot at me? You didn't give me latitude. Didn't I get elected and have a privilege and a right to talk? Thank you.
Mr. Mays, my response to your request for information is yes, you have the privilege and a right to talk, but you're only supposed to say germane to the thing that is on the table. And what was on the table was a discussion of the appeal. And the fact that I took a shot at you where you went far afield was basically taking pot shots of me. So I don't think you have grounds to complain.
Madam President?
No, Mr. Griggs, I'm sorry, but once the chair speaks for the second time, you're too late on an appeal. So I'd just like to say I'm just trying to achieve a meeting that is fair to all, is not unfairly monopolized, and that is courteous to the people we are going to be speaking with and asking questions. And the part of the motion that says and not interrupt speakers, okay, I think is very important, because if you ask a speaker a question.
Point of order.
What is your point of order?
Madam Chair,
you can't have a point of order in the middle of an appeal.
Yes, you can.
Well, that's true. No,
you can't. It's not true.
Excuse me. Stop speaking. Stop speaking. Actually, that is right. While you're on an appeal, you can't have a point of order. So anyway, we'll just vote on this, and it's the will of the body. You know, if you want everybody to be interrupted and not have everyone get a fair chance, then vote against the chair. If you agree with the chair, vote yes. Miss, that's your first warning, Miss Galloway. That's your first warning. You are out of order. You are out of order, Miss Galloway. So if you vote yes, you are voting with the chair. If you vote no, you are voting with, I think that was Miss Galloway.
Parliamentarian inquiry.
Roll call, please.
Parliamentarian inquiry. Please state the appeal, President Field.
The appeal is, let me get back to it. Janelle, you wanna, just for the record, write what you have down there that the appeal is? I don't want to misstate it.
That Mr. Davis did not say this discussion will start with those who have not had an opportunity to speak.
Oh, okay. All right. Then that's very specific. All right. So if you vote yes, you agree with the chair. If you vote no, you don't agree with the chair. Roll call.
Mr. Mays?
Who did you call?
Mr. Mays?
No.
Mr. Davis?
No.
Ms. Fields?
Yes.
Ms. Winfrey Carter?
No.
Mr. Winfrey?
No.
Ms. Galloway?
No.
Mr. Griggs?
No.
Ms. Worthing?
Yes.
Vote is 3 yes, 5 no.
Vote is 3 yes, 5 no, so the appeal wins.
Point of information.
What is your point of information, Ms. Galloway?
Did Mr. Griggs vote yes or no?
He voted yes.
He said no.
No, I voted no.
Yes, he did. Thank you.
I am very sorry,
Mr.
Griggs. I am very sorry. 2 to 6. I'm sorry. 2 yes, 6 no.
Okay, 2 yes, 6 no. Okay, so we're back to the motion is on the floor. Does anyone want additional discussion?
Madam President.
Ms. Galloway.
Madam President, I am hoping that council will begin the discussion, be able to say their 10 minutes or questions. What I'm hoping will not happen is that the attorneys will not be given the floor to use our platform to ask legitimate questions to give their information. And the reason why I say that is because I didn't really ask the attorneys any questions the other night. And the reason why I didn't is because as I listened to the one attorney, he's a male, I don't remember his name, as he began to speak, it just sounded as though he was very intimidating. He continued to say things like, if the city doesn't agree with this or support this, they will put the city in more liability, billions, he said, millions and billions of dollars. And so I want to make sure that they don't have the ability to monopolize a meeting in which this legislative body wants to get answers to their questions. And so if, in fact, we are going to limit the council to a 10-minute, I would like to make a substitute motion that the attorneys have the same limited information, not each, but as a collective group of people. And I so move that.
So as I'm understanding it, you are making a motion to amend the motion to include the attorneys who collectively will also only have 10 minutes to speak. Is that correct?
Correct.
Is there a second for that motion?
Madam Chair.
Mr. Davis?
I second.
It's been moved and seconded. Any discussion?
Madam Chair?
No.
Ms. Worthing?
Why would we limit the speaking of the attorneys that are here to answer our questions? If we each get 10 minutes, then the first person that goes, ask their questions and get an answer, that's the only person that gets their questions answered? I'm confused why we would do that. Also, what they said was true. We are out millions of dollars if we don't.
Point of order. Point of order.
Yeah.
What is
Madam
your point
President,
of order? What is your point of order?
Topic on the motion.
Right.
Mr. Davis, please quit commenting. You don't have the floor. I actually agree. She's moved on to another topic. Ms. Worthing, just confine your discussion to the motion that's on the floor. But I would like to add some clarification. I don't think the intent of the motion was to limit them in total, just also in rounds. So, is that correct, Ms. Galloway?
You are absolutely correct, Madam President.
Thank you. Ms. Worthing, you have the floor.
Yeah, I'm going to vote no. There's no reason to silence the people that are here to help us. So, yeah, my vote is no.
Is any other discussion on this motion?
Madam Chair.
Mr. Davis?
Thank you for indulging. I got a little issue here. Because I'm stuck on Councilman May's idea. If you're not satisfied, and we deserve to get answers this day. Point of order is sufficient to interrupt, and like he said, in a respectable manner, because they don't need us sitting here in 5 minutes if it's off topic of what I want to hear or where I'm trying to go. And we're here to get answers for the community. So, and also to my colleague, Councilwoman Galloway, and I think that's the same way. If an attorney is not going specific, point of order is sufficient in a nice manner, and just, have them to come back to the path of where you want to get to questioning and your answer. Because I'm here today to get answers. I ain't here to play games. I need to get answers. I'm not here to play games. So I interrupt a speaker if he's not germane to where I need to get these answers today. And that would help the community. Thank you for indulging.
Would anyone else like discussion on this motion?
Madam President.
Mr. Griggs.
I would like clarification of the motion, please. Please repeat it. Thank you.
Could you please repeat the motion, Ms. Galloway?
That the attorneys collectively would be limited in rounds of 10 minutes. And what I mean by that is they don't just get to go on and on and on and on. If we're going to be limited as a legislative body, even though we get turns, they should be a part of that as well so that there can be a fair dialogue.
Did that satisfy what you were looking for, Mr. Griggs?
That's not total 10 minutes, is it? That's 10 minutes each attorney, correct?
Not if three of them want to talk, Madam President, if I can.
Go ahead.
Yeah, so yeah, I'm saying collectively, if 3 of them want to talk in a row, that would mean 30 minutes. No. Hopefully they can answer our questions in the dialogue, but I don't want them to have more than 10 minutes and they just begin to talk and share the information without answering our questions. I'm hoping that they're here to answer our questions, and then in that they can...
What is your point of information, Mr. Davis?
And I'm thinking it's a legitimate point of information when I say this. When a colleague speaks at the 10 minutes, my information is this. You wrap up with the attorney and yourself within that 10 minutes.
Mr. Davis, that is not a request for him. That's a statement, Mr. Davis.
All right, I'm wrong.
Point of information is a question.
That was a question.
Could you repeat your question, please? Mr. Davis,
I'm going to try to repeat it. My question is this. We supposed to have 10 minutes. Are we supposed to have 10-minute increments each? Within the 10 minutes, my question is, whatever need to be said on either side of the fence is wrapped up in that 10 minutes. We go to the next colleague. That's my question.
Is that Mr. Griggs actually has the floor, but there's a dialogue because he wanted clarification from Ms. Galloway. Are you in agreement or not, Ms. Galloway, with what Mr. Davis's request for information was?
I don't. I want that to be on the body. I just want to make sure that the attorneys don't get to monopolize the meeting.
Okay, Mr. Griggs, you still have the floor.
Yeah, I'm understanding what Councilman Davis is saying, but I'm not sure it's the same thing Councilwoman Galloway is saying. I really need better clarification of this 10 minutes. Thanks.
Would anyone else care to speak? It's not spoken yet on discussion.
Madam President, for clarity, can I request an information from you or a point of information from you?
Sure.
I just wanted the attorney's time to mirror counsel so that we can smooth. And so maybe if what Councilman Davis is sharing the intent, I'm fine with that being the intent on this motion.
That's a request for information, what you just said?
Yes, I'm asking you or Mr. Davis, if that's his interpretation of how the council's 10 minutes go and it's mirroring that, that's fine with me. That what he's saying, though.
Since you've asked me a point of information, what I think, and I may be wrong, but what I think is being asked for in this motion is that council people have 10 minutes in rounds. And we haven't limited the number of rounds. So if you haven't had enough questions and answers in 10 minutes, then you'll get another round, but we'll take it in turns. And then the attorneys, when they answer those questions, are also limited to 10 minutes. Now, I want to say for clarification, we have both plaintiff attorneys and defendant attorneys here. So they're not all grouped together because they may have different perspectives, obviously. So I believe Ms. Galloway is asking that if there are 3 defendant attorneys when a question is answered, collectively their time is 10 minutes. And I assume the same would be for the plaintiff's attorneys. Is that correct, Ms. Galloway?
Well, Madam President, I just have to tell you, ma'am, I had no idea that the plaintiff attorneys were here.
And that's, Ms. Galloway, that's because you didn't allow me to do you the courtesy, to have the city attorney do you the courtesy of doing nothing more than introducing the attorneys on the line. And you stopped that.
But, Madam President, this is a recess meeting. The recess meeting...
Ms. Galloway, okay, you don't have the floor. I tried to explain it. You don't have the floor. Let's let Mr. Griggs finish, and then anyone else who's not had a round of discussion, a first round of discussion on this amended motion. Mr. Griggs, I think you still have time left. Janelle?
Yeah. Okay.
Yes, you have a couple minutes.
Okay, I'm still not straight, and I would rather Councilman Davis re-spoke the motion, or Janelle re-speak the motion. Maybe it's better if just Janelle would read the motion and let me make sure I can understand it, please. Thank you.
Okay, Mr. Griggs, you do understand this is not Mr. Davis's original motion. This is Ms. Galloway's amended motion.
I understand. That's why I need to ask Janelle to read the motion.
All right.
The amended motion is that the attorneys have 10 minutes collectively in rounds to state what they need to state.
Thank you, Janelle. It would seem to me that the clarification needs to be on the attorneys.
Madam President.
Mr. Davis?
I'm going to try to give clarity this time. Again, it's 8 council body members. We got 10 minutes each, which is 80 minutes. Within my 10 minutes, I don't care if I'm hearing from a plaintiff or attorney or administration. Within 10 minutes, I wrap up and go to the next colleague and they ask their question, and we go around and around because that's 80 minutes. If you do the way what I'm hearing now, we're going to be here 3 days, and we will be recessing this meeting as well. I hope you understand that time. Thank you.
Anyone else like to add discussion to this amended motion?
Madam President.
Mr. Winfrey.
Yes, just briefly. How hard is it for us to conduct a meeting? We've been here over 30 minutes, and we're still rambling on how we're going to proceed. It seems to me that all we need to do, we've got the attorneys here, both plaintiff and defendant attorneys. We've got all the councilmen here. It is proper for council persons to be able to ask their questions. If the attorneys are not answering it, there should be a point of order or at least a summons to the chair that my question is not being answered, and redirect the question, and so that attorney can answer that question, and then we move on. We don't have to sit here and keep going back and forth because we can't even get past first base. My goodness. Can we go ahead and we know how to act. At least we need to know how to act. I'm really appalled by all of this back and forth. All we need to do is ask the question. If the question is not being asked, then say to the president, he's not answering my question. Can we redirect this question so I can get my questions answered? And that shouldn't be taken away from the council person's time. I mean, let's move this thing on. Thank you, Madam President.
Thank you, Mr. Winfrey. Would anyone else like to discuss on the first round?
Madam Chair.
Well, then Ms. Worthing.
I just briefly want to say I have not agreed with Mr. Winfrey in a very long time, but I couldn't have said that better than myself. Thank you.
Thank you, Ms. Worthing. Any more discussion on the first round? Well, I'd like to say I'm also in agreement with Mr. Winfrey, but I do want to remind everyone that once again, you were using the word, we can call a point of order if they're not answering our question or going somewhere else. A point of order is what? It's a breach of the rules. And if you call a breach of the rules, I'm going to ask you what rule has been broken. And if no rule has been broken, then I'm going to deny your point of order. But I think Mr. Winfrey had a good suggestion. I think the council member can simply say, Madam Chair, the attorney is not answering my question. Could you please redirect them? I think that might be a more effective and efficient way and actually accurate way to achieve what you want to achieve on that. So I hope you're in agreement with me. Now, second round, who would like to speak?
Madam Chair, Councilwoman Galloway.
Ms. Galloway.
You know what? I agree exactly with what you guys said. So we can call the question and say no to this. If you're going to honor what you just said, and that if a council person actually says they're not answering my question, I will do whatever this body wants to do. I will withdraw, or we can call the question, and I myself will vote this down, as long as you are going to hold them accountable to answering our questions. Is that what you're saying you're going to do?
Ms. Galloway, I would like to respond to you. Okay, I don't think you have to call the question. I think everybody is probably pretty much ready, unless somebody else has something they want to say in discussion. And the only thing I want to address at the last is, once again, according to Mr. Mays, he thinks the chair is not allowed to interrupt. The chair is allowed to chair, and if I have to call something to order, I will do so. But I am not interrupting for no point in purpose or for my own purposes. So, would anyone else like a second round of discussion on this motion?
Yes, Madam Chair.
Mr. Davis.
Only thing I'm asking you is I'm hearing you say a chair can't be called to order?
No, Mr. Davis, that is not what I said, Mr. Davis.
I was just making sure. All right.
That is not what I said. I said if the chair has to call someone to order, the chair can do that. That's what chairing a meeting is.
Point of information, Madam President.
Ms. Galloway?
How does someone call the chair to order? Sounds like the question. Can you share that with this body?
Well, I certainly can. You can call for a true point of order if the chair is breaking a rule. But if the chair is not breaking a rule, then, and if you can't point to the rule that is being broken, then your point will be denied. It's just like any other way that we operate. It's no different. So, is everyone ready to vote? If so, roll call. The motion
Madam President, before you vote, may I chime in one last time?
Certainly, Mr. Mays. You haven't had your second round yet.
And it's real quick. Mr. Winfrey is right. Common sense prevails, fairness prevails, important issues prevails. We know every personality. That's why we have to do this preliminary talk. Do everybody raise their right hand and swear to be nice and get this business done? God bless you.
Thank you, Mr. Mays. The motion is, and Janelle, let's have you read it so everybody knows this is what is on the record as being the amended motion.
The attorneys have 10 minutes collectively in rounds to state what they need to state.
Well, I think it also included, Ms. Galloway, didn't your motion include that council members also have 10 minutes in rounds?
I just amended to include what we were already doing and added the attorney in, like Janelle just stated.
Okay, so the original motion was that each person gets 10 minutes per round, and then you go round and round if the questions aren't answered, no interrupting speakers, and then it was amended to say that the attorneys also have 10 minutes collectively in rounds to state what they need to state.
Thank you, Janelle. Roll call.
Mr. Davis.
Yes.
Ms. Fields.
Yes.
Ms. Winfrey Carter.
Yes.
Mr. Winfrey.
Yes.
Ms. Galloway.
Yes.
Mr. Griggs.
Yes.
Ms. Worthing.
Yes.
Mr. Mays.
Yes.
Vote is 8 yes, 0 no.
Vote is 8 yes, 0 no. The motion passes. Now, I'm going to go back to, as a way of courtesy, so council members know who is answering their questions or who they're asking questions of. Ms. Wheeler, would you please introduce the attorneys and let us know whether they are defendant or plaintiff attorneys?
Yes, thank you. Thank you, Councilwoman Fields. City Council members, good evening. We have a panel of attorneys this evening for this recess meeting to answer your very important questions about the water litigation that the City Council and your constituents would like answered. So we're glad to continue to make these opportunities available. On the line this evening, we have the attorneys representing the city in the water litigation. They are Assistant City Attorney Bill Kim, our outside legal counsel from Butzel Long, attorneys Rick Berg and Sheldon Klein, and also on the phone are some of the lawyers representing the citizens. Those lawyers on the line representing the citizens of Flint are attorneys Vincent Carter, Corey Stern, co-liaison counsel, and Ted Leopold, interim co-lead counsel. I would like to ask the plaintiffs' lawyers through you, Councilwoman Fields, those lawyers that are representing the citizens, if they'd be allowed to give a brief introduction.
Ms. Wheeler, I don't know about the brief introduction because City Council, I will ask City Council, how does this body feel? Would you allow the plaintiffs' defendants to give a brief introduction of themselves?
Madam Chair.
Just do a quick. Mr. Davis?
I say yes.
Okay, we'll do a little straw poll here.
Madam President.
Mr. Mays.
Yeah, and I would like for it to be brief, who their name, what firm they're with, and that type of thing. That brief.
Thank you, Mr. Mays. Anyone else? Okay, so Ms. Wheeler, it sounds like no one is objecting. So please have the plaintiff's attorneys briefly do an introduction of themselves.
Okay, thank you. Yes, and they're on the line now, so I'll go ahead and turn it over to those attorneys to identify themselves now. Please.
I could start. Can y'all hear me okay?
Yes, we can hear you.
Yeah.
Okay, thank you. I'm not exactly sure how to address y'all. This is a very formal proceeding, so I apologize if I screw up. Madam Chair and fellow council folks, my name is Corey Stern, Coreystern. I'm a partner at Levy Konigsberg. That's a firm in New York City. You could probably hear from the way I talk that I came to New York by way of Atlanta, Georgia. I represent about 2,700 individual children whose cases I have filed individually in both Genesee County as well as in the Federal District Court in the Eastern District of Michigan. In 2016, I was appointed by Judge Richard Ewell, who's now retired, as lead counsel for all plaintiffs in the Genesee County Circuit Court. And in the summer of 2017, I was appointed by Judge Judith Levy in the Eastern District of Michigan as co-liaison counsel for individual plaintiffs who were alleging personal injuries and property damage. I'm happy to tell you more about myself, but I could tell from the I'm happy to go into more detail, but at this point, I'll pass to my local and co-counsel in the case, Mr. Vincent Carter.
Good evening, ladies and gentlemen. My name is Attorney Vincent Carter. I will keep my comments brief also. I've been working with Corey Stern from the beginning of this matter as local counsel. I am from the area. My firm is called Robinson, Carter, and Crawford. And that'll be it for me. Thank you.
Good evening, council members, Madam Chair. My name is Ted Leopold. I'm a partner with the law firm of Cohen, Milstein, Sellers, and Toll. I specialize in the area of consumer justice litigation and have a national practice, and was court appointed by Judge Levy in the Eastern District of Michigan in the Ann Arbor location to be the co-lead class counsel in the Flint water crisis.
May I just ask, Mr. Leopold, who do you represent?
I represent the class side of the case, so we represent adults, business, and property owners.
And Mr. Carter, I didn't quite catch. Who do you represent?
Yes, ma'am. My name is Henry.
Point of order, Madam Chair.
What is your point of order, Mr. Mays?
Wouldn't it be proper, what all we said, to just let them keep going round real quick? You can get to some of that later.
Mr. Mays, that wasn't a point of order. No rule has been broken, so I deny your point of order. Mr. Carter has already gone round once, but he failed to say who he represents. So I was just trying to clarify that for counsel. So your point
of information.
What is your point of information, Mr. Mays?
Didn't he say he was working with the firm locally that had just spoke earlier, before him?
He may have, Mr. Mays. If so, I didn't catch it. In which case, Mr. Carter, do you also represent the children?
Yes. I represent the same folks that Corey Stern represents. We work together. I am local counsel for Levy Königsberg.
Thank you very much. All right, so now let's begin our rounds of counsel people. Who has not spoken yet at the last meeting before we recessed? Who would like a turn to ask questions?
Point of information.
What is your point of information, Ms. Galloway?
Madam President, are we going to hear for the attorneys on the city side and the council so that the people know who's on the call from the other side?
We can, Ms. Galloway. Go ahead, Ms. Wheeler.
Yeah, I was just trying to keep things short, but yeah, attorney, the attorneys, I'll turn it over to them. Bill Kim is Assistant City Attorney for the city. And if you go ahead, Rick and Sheldon.
Good evening, ladies and gentlemen of the council. This is Rick Berg. I spoke late on Monday evening. I'm a partner at Butts & Long, and I represent the city of Flint as a defendant in the water crisis cases.
And excuse me. This is Sheldon Klein. I am also a partner at Butts & Long, working with Rick Berg. We have been representing the city since spring of 2016. My background is in class actions and other mass litigation of this sort.
Thank you,
and good evening, council members. This is Assistant City Attorney Bill Kim, and you're familiar with me, so I won't take up any more of your time.
Thank you. Okay, now let's begin our council rounds. Which council member who's not had an opportunity to speak yet, to ask questions, would like to go first? What is your point of order, Ms. Galloway?
Madam Chair, the rule that you're breaching is the one that council just voted on. It was not
just a moment, Ms. Galloway. I can't hear you. I'm getting a lot of static.
Can you hear me now, Madam President?
I can. Okay, please say what you said again.
So the breach is this council just appealed you saying that those that didn't speak get to speak first, in which that appeal was supported, and now you're beginning to implement that again. That's the breach. You're going against what council voted on.
Okay, Ms. Galloway. I understand. Well, let's say then, maybe the council people, Ms. Galloway, just a moment. Just a moment. What is your point of information, Ms. Galloway?
Can we start like we do on voting, where we start 1, 2, 3, and then go around? It's 10 minutes. We already voted on that. That's my point of information, my request point of information. Can we start at the beginning like we normally do?
Well, normally under discussion, people just holler out for the floor, but I'm willing to do that. And since we always go from first ward on, I'm going to go backwards this time, as you often did in council discussion. We will start with Ms. Worthing of the 9th Ward.
I have no questions at this time. Thank you.
Thank you, Ms. Worthing. Mr. Griggs.
Is one of the attorneys present that is dealing with property damage? For example, hot water heaters or steam boilers?
Yes, sir. This is Ted Leopold, co-lead counsel for the class, which includes property-related matters. What question could I try to answer?
Gentlemen, just one moment. We're getting all this squeaky static, and I don't know why. Do you know, Janelle? Can we stop that?
Madam President,
yes,
Davina?
Yes.
Yes.
I'm just going to say that it is one of the attorneys.
Hello, it sounds like it's one of the attorneys. Are you
listening to the meeting at the same time is what it sounded like to me. It's like they've got it playing in the background.
I'm just on the phone.
This is Corey Stern. I'm just on my phone, and it's on mute when I'm not speaking.
It's a different attorney. I'm going to unmute them.
On mute when I'm not speaking also.
Okay, so all the attorneys are not also listening to the meeting as well as being on the meeting. That's what's causing the static, please. Okay, so I am sorry, Mr. Griggs, and I think Mr. Leopold was speaking, answering your question. Mr. Leopold?
Yes, I asked what specific question could I try to answer for the council, and happy to do as best I can.
Okay. What does one do to request reimbursement for a damaged hot water heater or steam boiler? In other words,
yes,
property damage.
Yes, sir.
And is that all that would be in property damage?
Well, it will encompass more than that, but the process or procedure, and this will go for adults, even minor children, as Corey can explain, and businesses, is on, as I believe you may have seen in the papers, yesterday we had a hearing before Judge Levy, and she set the preliminary approval hearing for December 21st at 1:30, and what that means is she is going to consider preliminarily whether to approve the settlement. If she does approve it at that time, the next step will be the administrator and all of us on the attorney side will work to get registration forms out to all of the community residents, homeowners, businesses, adults, those represented by attorneys for the minors, etc. And they will fill out those registration forms, which will begin the process to get individuals such as you or others who have property damage to fill out a claims form and then get reimbursed from a financial recovery. I should say, also depending upon the final approval, which will happen several months from now, before Judge Levy, if she were to both preliminarily approve it and then the final approval. Probably sometime, I would think, in May or somewhere around there.
Okay, thank you.
Yes, sir.
Are you through, Mr. Griggs?
Yes, thank you.
Okay, and Janelle, I'm assuming you are the timekeeper for this.
Yes.
Okay, so for Mr. Griggs, we move to Ms. Galloway.
Thank you. It's 6:34 p.m. My question to the attorneys representing the city of Flint: why is the city of Flint a defendant in this lawsuit?
This is Rick Berg, Council Member Galloway. It's not up to the city whether they're a defendant. The city's a defendant because the lawyers that represent the citizens choose who they're going to name in their lawsuits. The lawyers that represent the plaintiffs decide who they think might be responsible for the water crisis, and so they named as defendants state departments and the state employees that were in the Department of Environmental Quality and et cetera. And they named engineering companies, and they named the city and city employees because they felt that each of those parties could perhaps be proven to be responsible.
So with that in mind, thank you for that. Okay, I think I got. So when they named the city, what specifically did they name the city as being responsible? Are we responsible because of the employees that were a part of it, or is the city a defendant in and of themselves? I know that anybody can sue anybody. But my question is, someone that has sat on this council since the water crisis started, and the fact that we were under an emergency manager, the fact that the legislative body voted to get off of the Flint River and go back to Detroit, and we were overridden, I'm just trying to understand our liability and why we are a part of it. Outside of anybody.
The answer to your question is that the city of Flint, as a municipality, is itself a defendant, along with a number of employees or now former employees of the city and the emergency managers. All of those were named as defendants, or are still named as defendants.
So, Mr. Burke, is there anything that the city could have done to do we have any protection considering what happened under the leadership and government of the emergency manager, thus the state of Michigan?
That's a very complex legal question that has been fought in a number of different battles throughout the 4.5 years that this has been going on. And to the law itself associates the city and the emergency manager such that the emergency manager law says that the city is responsible for the emergency managers and to defend them in the case. And so they also have, it's somewhat confusing because they've also been held to be state officials. But in terms of on whose behalf they were acting, and whether or not their actions would make the city liable as opposed to the state, some of that is still up in the air. Some of that still could go either way if it were to have to go to trial.
Okay, and thank you, Mr. Burke. And the reason why I was asking that is because when I went and looked at some of the documentation, it showed Darnell Early, represented by I think William Kim. Please forgive me if I made a mistake. And so it showed some of the very people being represented by the city. So my next question to you, Mr. Burke, and if I misheard you, please feel free to correct me. The other night when you spoke, you said if the city does not in fact agree to the $20 million, they run the risk of this costing the city millions, and it seems like you said and billions of dollars, and it seems like you referenced a previous case. I don't know if that was the Genesee Towers. Can you clarify that for me in my last 5 minutes without taking all of my last 5 minutes?
I'll do my best to be brief. Yes, I did say that, and it's really just sort of a mathematical thing. I mean, that's why I used the figures that I did. If we were to assume, for example, that each of the 2,700 children that Mr. Stern said he represents, if all of them went to trial, and if all of them obtained a judgment at that trial of $1 million against the city, that's $2.7 billion. So it is theoretically possible that if the city doesn't settle and has to stay in the case and proceed with the litigation because it's not settling, if it's not settling, then it's still in the litigation.
Okay. And Mr. Burke, I get that. Now I understand. But why, and the reason why I'm asking why you referenced the Genesee Towers is because, in my opinion, Genesee Tower was totally different. That was a difference that a mayor did not agree with. This is the poisoning of a community, and so that's why I was wondering why you referenced that specifically. And I don't want you to take up my time, Mr. Attorney Burke.
Just a moment, please. I'm just asking that you don't step on each other's sentences.
Well, I was still talking. And so, Attorney Burke, I know that you're going to have time. I'm just wondering what made you reference that specific case?
I can answer that question very clearly. I was referencing it because it was mentioned in a newspaper story, and it was mentioned because it said it was an $8 million judgment that caused there to be an increase in everybody's property taxes of $150 per property owner. If the city is unable to pay a judgment, if there's a very large judgment and the city simply doesn't have the cash to pay it, the law requires the city to assess a tax on all property owners. And so, like the Genesee Towers case, if the city were to lose enough of these water crisis cases, it would have to do the same thing. That's why they're alike.
So, Attorney Burke, in my last question, I have 3 minutes. If the city decides not to settle, the state will continue to settle, and the city would be on their own responsible for whatever came against them. Is that what is being communicated?
Yes, ma'am. The way the state proposed the settlement is that the state, which had negotiated for years with the two other gentlemen that are on the phone with us, they had reached a settlement agreement that made it possible for the city to join if the city had enough funds that both the state and the plaintiffs would agree that the city could become a part of that agreement. And the city then negotiated with its insurance company and obtained those funds, and the state and the plaintiffs agreed, yes, you can become a part of this agreement. If the city does not become part of the agreement, then it's still in all of the cases, and the state will proceed with its $600 million settlement and leave the city out of it.
Okay, thank you. And then I have a question for the attorneys that represent the plaintiffs. I heard multiple attorneys, well, it seems like all three of them said that they were appointed by Judge Levy. How did that process work? And if somebody can say it really quick, if there was an interview process, how did you get chosen by the judge to represent the plaintiffs? I got 1 minute. It's 6:43. I started at 6:34.
I'm going to do it. This is Ted Leopold. I'm going to do it in 30 seconds. We were requested by Judge Levy to provide papers of our backgrounds, experience, education, involvement in these and similar types of cases around the country, and along with many other attorneys. And Judge Levy reviewed all of those filings, interviewed, and made the selection for Corey Stern as liaison counsel and myself and Michael Pitt for co-lead class counsel.
Perfect. I'm at 6:44. Madam President, that's my first round. Thank you so much.
You're welcome, Ms. Galloway. Okay, next is Mr. Winfrey.
Thank you, Madam President. this is for both attorneys. I'd like for both plaintiff and defendant's attorneys to respond to this question. There are a number of constituents here in the city of Flint from all quadrants of the city that believe that if this body, if we vote this $20 million lawsuit up, if we vote in the affirmative, if we vote it up, that we're voting on this $641 million settlement. And I'd like for each of you to briefly explain, because I don't believe that that's what it is. I don't believe that whether we vote on this $20 million, whether we vote it up or down, I know that it has a relationship with the $641 million, but I don't believe that if I decide to say yes, that that's going to impact that $641 million. Do you understand my question? So I'm asking you, would you explain the $641 million as it relates to the $20 million lawsuit? I understand the reason for the $20 million lawsuit. I mean, I know it gets us out of any future lawsuits as it relates to this settlement.
So this is Corey Stern, Madam Chair and other chair people. Thank you. It may not be the answer that you would love to hear.
I just want to hear the truth. That's all.
Yeah, sure. Yeah. The reality is that there's $600 million that's been agreed to from the state of Michigan. There's $20 million that's been agreed to be paid by McLaren Hospital. There's $1,250,000 that's been agreed to be paid by Rowe, an engineering company in Flint. And there's $20 million potentially available from the city of Flint pending your vote, I guess. If the city council chooses to vote no on the $20 million, then the settlement will still go before Judge Levy on the $621 million, $250,000 between McLaren, the state, and Rowe. I think that it's commendable, and I'm not saying that gratuitously. I've spent half of the last 5 years in Flint before the pandemic. I think it's commendable to be conscientious, if not advocating for my clients. I mean, you're literally taking positions and asking wonderful questions because you want to make sure that my clients and people like my clients are taken care of in a meaningful way. The reality is, whether any of us likes it or not, that the other parts of this settlement are going to go before Judge Levy, irrespective of the $20 million from the city of Flint.
Thank you. I'd like to hear from the defense attorneys.
This is Sheldon.
Go ahead, Sheldon.
Yeah, so you can hear a different voice at least. I don't have a whole lot to add to what Corey just said. It does just become a $621 million settlement with all of the folks contributing to that 621 getting out of this litigation and the city of Flint not getting out.
So then what you're saying is that if the city council votes in the affirmative for the $20 million, then that gets us out of the litigation.
So this is Corey. Let me just clarify. You voting to put the $20 million in does not guarantee that there's a settlement for anybody, because the court still needs to approve the settlement, whether it's $621 million or $641 million, nor does it take away your right or anybody else's right to oppose all the things in the settlement that you may not like, or to continue with the case if you have one or if someone you love has one, even if the court does approve it. And so if you, councilmen, say, yes, I vote in favor of the $20 million, as a resident of Flint, you could still stand up at some point in federal court, either in writing or in person, and say, Your Honor, my name is Councilman, and I'm sorry, I don't know which councilman you are. I really apologize, but my name is Councilman Smith, and I voted because I understood from all of the council meetings that this $20 million gave the city of Flint an opportunity to be out of this litigation. But as a citizen, as a member of the community, I feel that these people are getting too much, or nobody's getting enough, or whatever, I don't think that the structure is fair. I don't believe that the allocation is fair. You're not voting on the settlement. And, sometimes I make decisions as a lawyer that I hate, even though if I were making the decision as a dad or as a kid or as a brother or as a friend, I might make a different decision. And I'm not suggesting you vote a certain way. I'm not here to, the things going forward, with or without the city's money. But the reality is it's a technicality on some level. And even if you put the $20 million in, there's just as good a chance that the judge determines that it's not a good settlement, because it's not going to be necessarily based on the amount. You've seen, and I've read posts online, there's a lot of intricacies involved in this, and there's plenty of nuance for the judge to potentially find that it's a great deal, or it's a bad deal, or this should be made better, or this should be fixed. But the $20 million is literally just a vote to give the city an opportunity to get out.
And all I was concerned about is what we were voting on, because a lot of people think that if we vote in the negative on this $20 million, that settlement won't go forward, and I know that's not the truth. I'd like to hear from the defense attorneys, please.
Again, this is Sheldon Klein, and again, I really don't have a lot to add to what Corey said. It was a very thin and accurate answer.
Okay, thank you, sir. Madam President, that's all I have right now.
Thank you, Mr. Winfrey. Next is Ms. Winfrey Carter.
Thank you, Madam President. I think, let me see. I would like to ask, and I think this goes to the plaintiff lawyers, what input did the team get from those affected by the water crisis, and who was responsible for the distribution of the formula for the settlement as far as the $600 million?
This is Ted. You want to go? Ted Leopold. Yeah, I think this is Ted Leopold, because Corey, who represents individuals, specific individuals, his response is a little bit different than us on the class side. So in a class action case, we represent thousands and thousands of people in the community, if you will. However, because from a management standpoint, that would be too difficult, the law in class actions, in the kind of case that this is, at least from our perspective, is that certain class representatives, in other words, people in the community, are representative of the whole. And I don't have all of the names in front of me, but there are handfuls, 10 or so people that represent the entire community. In other words, they are obligated by the court to act in the best interest of the entire class. So as we began to negotiate with the state and the other parties, we kept them abreast of everything, and they have signed off on believing that in their capacity as the class representatives for the whole, this settlement is the best for the community. That's number one. The second part of your answer is, or your question is about the funds. And that's a very good question, because we as class counsel were able to negotiate a gross amount. In other words, if we were just negotiating with the state, the $600 million, we can say we believe that is a reasonable settlement with the state. However, since there are a couple of different categories of classes, property, adults, etc., we would be in a conflict if we said X percentage goes here or X percentage goes there. So Judge Levy appointed for a subclass counsel independently to represent those classes. So there was specific counsel appointed by Judge Levy to represent adults, to represent property, to represent minors, to represent businesses. And they negotiated of how that money would be split up amongst that group. Corey, it's probably best that you go from there.
I don't have, this is Corey again, Madam Chair and other chairpersons. I don't have a ton to add. I can only say that in the course of the, in 5 years of litigating these cases, I've not only, negotiated a settlement, but I've had hundreds of my clients evaluated by neuropsychologists, pediatricians, and economists to try and determine a value. If we were to have a trial, it wouldn't be one trial for 2,700 kids. It would be a trial for one kid, and then another trial for another kid, and then another trial for another kid. And so every child at some point in time has to be evaluated to determine damages, to determine, how hurt is someone. When you ask a jury for money, it's got to be more than, as a plaintiff's lawyer, more than just, look how bad this kid's hurt. I have to be able to identify how and why they should be paid whatever amount of money. And so in conjunction with all of the things that Mr. Leopold said, we actually worked up hundreds of these cases to see what the best case scenario was for all of them in terms of values. If we hit it out of the park every single time, what would this kid get? What would this kid get? And then as a lawyer, I have to, and what I did, in conjunction with 20 other lawyers who were all settling this, what's the worst case scenario? What happens if it's determined that the city has no liability, as Madam Councilwoman, alluded to a little earlier? As a plaintiff's lawyer, of course I'm going to sue the city. But as a trial lawyer, I have to know there's always a possibility that perhaps what she alluded to is correct. Maybe the city has no responsibility. Maybe the state gets out of the case because it's immune from liability, even though I think they've done some really bad things. Maybe the engineering companies weren't there at the right time or have experts that testify that they did nothing wrong and a jury believes them. So in addition to negotiating the larger sum, we did our own, literally internal case-by-case evaluation to try and get an understanding of what the ranges were, and then to make sure that we were settling the case in a way where those ranges could be met by way of a settlement rather than taking the risk at trial. And then the last thing I'll add is there are at least two major defendants who are not part of this settlement. And so when we talk about $641,250,000, again, that's McLaren, State of Michigan, City of Flint, and Roe. Veolia has somewhere around $300 to $400 million in insurance. It's not a life insurance policy. It doesn't mean we just get it. We have to earn it. We have to prove it. But there's money out there. The Environmental Protection Agency has thousands of cases filed against it, and they are not part of this litigation. There's a company called LAN, which did engineering work for the city of Flint. They are a part of this, and they are not a part of the settlement. And so from 30,000 feet or from 2,000 feet or wherever you stand, you can have whatever feelings you do about the total amount or about the $20 million. The reality is this is just the beginning. And the last thing I'll say is, a month ago, I filed a lawsuit against 3 banks. You may have read about it. You may not care about it. It may be nonsense. The judge may throw it out. But I filed a lawsuit against 3 banks who made the bonding for the Karagandhi Water Authority possible, which I allege on behalf of all the kids, had they not made that possible, this never would have happened. And so for anybody who thinks we'll just settle in, we'll get the heck out of there and we'll be done, there's 3 or 4 more defendants that are still in it, and new defendants are being sued all the time. So this is just part of the puzzle, not the whole puzzle. So sorry to expound a little bit, but I hope it answered your question in addition to Mr. Leopold.
Thank you. Well, okay, so my next question, and this also goes to Attorney Stern, I believe. Let's say maybe 5 years up the line here, 5 years later, a child finds out, or someone finds out that they had effects from the lead. Can they turn around and bring back a lawsuit?
So thank you, Madam Councilwoman.
If they were denied or they opt out.
Yes, ma'am.
Can they come back 5 years later and bring back a lawsuit?
So the short answer to the question is yes. The longer answer to the question is it's dependent on their age, because there's a statute of limitations in Michigan that provides how long anybody has to file a lawsuit. And in Michigan, you have, I think it's 1 year after your 18th birthday. So if I was a child that was born in 2000, and if I was born in 2010, and I was exposed to the water in 2014, I would have until my 19th birthday, which would be 2029, to bring a lawsuit. So part of this settlement includes, A, if you're a kid and you don't participate in this settlement, you absolutely have the ability to file a lawsuit later on. If you have a lawsuit and you decide not to participate, you have the ability to continue your lawsuit. The only way that you would not be able to do anything in 5 years is if you participate in the lawsuit and a guardian or a parent signs a waiver on your behalf and you settle your case. You can never, after settling a case, then come back and say, well, not never, but it'd be very hard to come back and say, I changed my mind. I know I had the money, but I don't want to settle the case anymore 5 years later.
Okay. So basically, if a person signs on and is denied, if it is found out 5 years later, can they turn around and bring back a lawsuit? And basically, you're saying they probably can. They can.
Any child, if in 5 years someone is under 19 years,
an adult or anybody.
No. So you asked about kids. So kids have a statute of limitations until they turn 19 years old.
What about adults?
Adults.
Just a minute here. Janelle, is that a time?
Yes, ma'am.
Is that the timer?
Yes, ma'am.
Okay, let's allow Ms. Winfrey Carter's question to be answered, and then wrap up.
Ted, do you want to answer the adult question, or would you like for me to?
No, I'm happy to. So, the adults don't have the ability that minors do for clear reasons. So adults, they can opt out of the settlement if that's what they would like to do. There'll be a time frame by which they will have to do that, and they will have to sign paperwork if the preliminary approval process moves forward, if Judge Levy preliminary approves it. Mm-hmm. If they opt out, then they can do one of two things. They could do nothing, and they will not get any recovery based upon the damages or the monetary recoveries for their types of injuries, whether it's this is the same for property owners or business or an adult, or they must then go and seek their own counsel and begin the litigation anew on their own on an individual basis. So they have the ability to do that, but they're going to have to find an attorney that would be willing to take on just their case and to do the same things that we all have been doing for the last 5 or so years.
Okay. Thank you. Thank you, guys, and thank you, Madam Chair.
Okay. So now we've heard from the 9th, 8th, 7th, 6th, and 5th Ward. I am councilperson for the 4th Ward, and I have a couple questions. This is sometimes a tad confusing, understanding the nuances here. We're being told that if we agree to the $20 million settlement from our insurers to add to the case, that we have settled all the lawsuits that have currently been filed against us. Is that true or not? Regarding these water issues.
Sheldon, you want to take? Go ahead.
Sure. There is a nuance here, and Ted alluded it to in his last answer when he talked about opt-outs. If there's someone who says, I want nothing to do with the settlement, I'm going to bring my own lawsuit, they have the right to do so. And if someone does that, we are still dealing with that individual lawsuit. That's a whole lot different from what we're facing now, And it's just the nature. There was nothing that we could have done in the settlement agreement that would change that would have given a 100% guarantee that everything is going to go away.
Okay. All right. My next question is, maybe Ms. Wheeler, you know the answer to this. I was told, and I don't know whether this is accurate, but Attorney Lois Fletcher had been calling council people, lobbying against the settlement, stating that he wanted $14 million for his plaintiffs. I was told that his cases were dismissed. Is that true?
Angela, you want me to take this?
Yeah, go ahead.
This is Rick Berg. We're actively litigating with Mr. Fletcher in his cases, and so that restricts a great deal as to what we have to say. He did have one case dismissed. The Court of Appeals reinstated it, and so we are still litigating it. And beyond that, it's probably not prudent to talk in great deal about his cases in particular.
Okay, but if we agree to the $20 million, first of all, is Mr. Fletcher's plaintiffs included in this larger settlement, or are they not?
No, they are. In the settlement agreement, it talks about the right of people to make claims for refunds of water bills that they've paid, and his cases are restricted to seeking damages for water refunds.
Okay, so in this settlement, if we use our insurance company's funds, okay, Mr. Fletcher's cases are included in that, but he's just part and parcel of the larger whole, correct?
That is correct. That's the way the settlement agreement is proposed. But as the other lawyers have pointed out, Judge Levy has not approved anything yet. So the way it's proposed right now, what you say is correct.
Okay. All right. Well, then I want to switch topics a bit, and I'm not sure if Ms. Wheeler can answer this or who can answer this. There's a lot of confusion out there regarding the City of Flint's insurance company. And there's confusion with rumors, I don't know if they're misconceptions, whatever, that number one, that the city is self-insured and didn't have an insurance company, or who are these insurance companies that are agreeing to settle for $20 million on our behalf? Why are they now, we do have an insurance company and we're not self-insured?
Angela, you want me to take this one again?
Yeah, I was going to start off with saying the city does have an excess carrier, but yeah, you and Bill can respond.
Sure.
You want to take this,
the city. Yeah, no, I can do it. The city is self-insured up to a certain amount of money, and it has what are called excess insurance policies. Excess insurance policies insure you once your exposure exceeds a certain amount, and the city's excess policies for the years related to the Flint water crisis are $10 million per year. And so the $20 million is the limit of that excess policy for 1 year and another year. I mean, that's kind of the way the insurance company rationalized what they thought they could be exposed to if the city had to go through all of the litigation. The insurance policies are a little bit unusual from the standpoint that they are reimbursement policies. They're really only supposed to pay after there's been a judgment entered or after there's been a settlement that's actually been consummated. But because of the nature of the proposal that the state made, that you could only join the settlement if you had the money, they realized that the only way the city was ever going to really have an opportunity to settle was if they said, we will offer up the policy proceeds before you get to judgment or before you actually are in the settlement, so that you have something to offer. And so anyone that says, no, the city didn't have any insurance policies, that's just not correct. I mean, it's just not correct.
Rick, if I can add on to that.
Go ahead.
I apologize. Because I think this is an important point. Yes, of course there's insurance policies. Where else did the $20 million come from? But if we do not do this settlement, the insurance companies would have very good arguments that under the policies they owe us less money or even nothing at all. And I don't want to get into the nuance of the policies, but it's not as if the $20 million is necessarily going to be there down the road.
Okay, well, I know through some of these previous discussions, we're being told that if we don't agree to the $20 million settlement, which is at the heart of what City Council is voting on in the water litigation cases, we're not voting on, we can't change, as you've explained, the $600 million settlement. We can't change the terms. We can't change the classes, the formulas. We have no authority to change any of that. The only thing that the city and therefore the council would be voting on is whether to accept this offer from the insurance company. They will kick in $20 million to the larger pot, or we're being told they won't kick in anything. And so then we would be liable once again, I guess, if we're sued case by case by case by case, the city has to come up with the money if there were judgments. Is that correct?
It's mostly correct. It's possible that if we were to get to lawsuit and jury trial number 1, and there were a judgment entered against the city, and we turn to the insurance company and say, we think the policy should cover us on this, that they would say yes. It's possible. It's also possible they would say no. It sort of depends on the particular lawsuit and what the judgment is for and how it came out. But that's going to be determined on a case-by-case basis. It's different. It's not as if if we decline the settlement, the insurance company will still give the city $20 million that we can sit on like a nest egg and use. That's not going to happen. So the $20 million is only there for purposes of enabling the city to get into the settlement agreement.
Okay. All right. Well, I think I understand this. So there are a lot of nuances here for laymen, all right? If, let's say, we did have to go case by case, and the insurance company said, no, we're not going to pay on that claim or judgment, would we then have to hire yet more attorneys to try to go after the insurance company to make them pay on these individual judgments?
That is an option that the city would have. And if the city thought that it had a good claim against the insurance company and that they were wrong, that they were refusing to pay on the policies wrongfully, the city could do that. And if they were refusing, that's really the only way you can make them pay is to sue them. So basically, that's correct.
Okay. So what I see out of that is a never-ending series of lawsuits against trying to defend against plaintiffs and if insurance companies won't pay out individually. Well, it sounds like my time is up. Thank you, gentlemen. I'd like to move on then to Mr. Davis, since Mr. Guerrero is not here.
Thank you, Madam Chair. Thank you. I'd like to talk to the defense as well as the plaintiff attorneys for a second. And I'm coming from a different angle because it's very frustrating. We waited all these years after the poisoning. Nobody went to jail, penitentiary, or nothing. And then the residents finally get a day in court. And it don't look good at all. What am I saying? Why in the world all the attorneys from out of town? We got Fiker, you got all these other Mantleys and all these local great attorneys. But besides that, I'm coming in the name of the... Hello? Hello? Hello?
Who is that interrupted? Go ahead, Mr. Davis. I don't know who that was that interrupted.
Yeah, thank you, Madam Chair. But anyway, I'm coming in the name of the homeowners in this city called Flint. The treatment is deplorable. The way they did us is just, I'm not cussing, but it don't make no sense. Question I have, this $20 million insurance policy, we're going to have to make a vote on the 14th of December. Now, it's information going around the community. We should vote no. Then you have the side that once you put light on it, they say yes. Now, I know I want to ask the city attorneys as well, or whoever could give me a truthful answer without being under oath right now. What's the best thing if somebody, we're already impoverished and we got on the insurance because I'm mad about tens of thousands of people, plaintiffs, got money in the city of Flint and everybody didn't because everybody was poisoned by this water. But I'll come back and visit that. What happens if we vote no on December the 20 on the 14th about what happened with our insurance policy? I know we can't change nothing that happened with that $600 million, but explain it to this community while we have their ear attentive. Anybody that'd like to respond?
Sheldon, you want me to go with this, or do you want to take it?
The floor is yours.
If you vote no, and that means that the settlement agreement is null and void for the city. That's basically what the settlement agreement says. If city council doesn't vote in favor of it, then basically the city drops out of the settlement agreement.
Okay, so question. I'm not cutting you off, but question. I understand, Madam Chair, but question. What does that mean for a homeowner or a taxpayer in this community as you respond? Thank you. Continue.
It means that the lawsuits continue against the city. The city will have to continue to defend those lawsuits, which means, of course, that it has all of the legal fees that it costs to defend those lawsuits. It will probably take a number of years before all of those lawsuits get fully resolved against the city. It's possible some of those lawsuits could go the city's way and the city might defend successfully and get out of some of them. It's possible that the city would lose some of those lawsuits. And if as we discussed a little bit earlier, if the city has large judgments against it in the millions or theoretically billions of dollars after a number of lawsuits in a number of years, those judgments, I'll just finish real quick. Those judgments have to be put on the tax rolls, and that's what affects the citizens, because they end up paying for the city's liability, because that's the law requires the city to assess taxes if it can't pay judgments.
And the only thing I want clarity is when you refer to the city, can you make clarity who is the city? Is that the residents or is that the municipality, the city, or some other income source?
So it's the city
is it taxes
of
or
Flint.
what? Yes.
The city of Flint.
Yes.
The city of Flint municipality.
I'm sorry. I just wanted Mr. Davis to allow you to answer his question.
Yes, ma'am.
Okay. The city of Flint municipality, the governmental entity, is the defendant, and that's the party that is that if there's a judgment against that governmental entity, and the city of Flint is held, in a jury verdict, is held to be liable to Mr. Bob Smith for $1 million, and the city, in theory, in my example, doesn't have that $1 million to write a check, then the city has to put that $1 million on the tax rolls. And so that assessment, that tax assessment, increases every property owner's property taxes. And so would the next judgment, and so would the next judgment, and so would the next judgment. And so the settlement is a valuable thing for the city and for the citizens, because it avoids that possibility.
So you'd be assessed higher taxes, and we're already on a fixed income and impoverished. And a lot of us already in foreclosure.
If the city loses enough, if the judgments happen and if they are high, that's correct. If the city wins every lawsuit from here for the next 5 years, then it's just the cost of legal fees, which are certainly significant, but not as significant as the judgments would be. But we have to be realistic, and we don't know. It's unpredictable as to how much and how many judgments might be entered against the city, and that's why people settle cases, because there is unpredictability.
Well, you really answered that thoroughly for me. It could be assessed higher taxes on the residents, and that's the answer I was looking for. It falls back to the residents. And now I'm not going to answer everything I want to at this time, but I want to go to the plaintiff's attorney's question. Now, everybody I know in the city of Flint, and I've been here all my life, a lot of people died from this water. A lot of people are sick and dying, and we got COVID on top of it. And it caused pre-existing conditions. Question: why wasn't everybody compensated without documentation for the damages that was done and brought on by the government? This is not right. Nasser only had 200 residents that he did up in Michigan State. Whatever he did, they settled for $500 million. 85,000 people, last I checked, right here in the population of the city of Flint. And we have to come up with documentation which no doctor want to sign on to saying it's related to the water. Legionnaire's disease, people laying in graves. And we're getting crumbs, which I understand we can't change. And you say more litigation to come. But I want to ask you, y'all got tens of thousands of people signed. The poorest of the poorest don't have internet or no way to know what's going on in this community. How can they catch this train that already left the station? I understand that we can't change the settlement. I also understand it's already in Judge Levy's court for a decision. But what can the actual plaintiff attorney say? The residents that knows nothing about it, because we had a lot of misinformation from these attorneys, Crump, Hill Hop, and all this other stuff coming across TV. We don't know what to do. But I can't see $641.2 million coming here, and we don't get a dime at the end of the tunnel because it's so disrespectful. Who would like to answer that question for me?
This is Corey Stern. I mean, I'm happy to take a shot at it. I've represented brain damaged kids from lead poisoning my entire career. I've been practicing law for 20 years. And I also, by the way, represent victims of sexual abuse. Not that that has anything to do with Flint, but you referenced the Nasser case. I didn't have a single client who was in the Nasser settlement, but I also represent those folks. I can tell you and I also have two children who are 11 and 12, and the reality is there's no amount of money. There's literally no amount of money that someone could ever pay me to go back in time to when my kids were 0 to 11 or 12 and have them get lead poisoning. There is not enough money to pay them if they did. If either of them were ever sexually abused by a gymnastics doctor or a coach or a counselor or a teacher, there's literally no. I would want to kill the person. I'm not. I'm speaking as frankly as I can. This settlement is designed to try and compensate everybody and to put as little of a burden on everybody as possible in order for them to get compensation. There are ways for everyone to get into this settlement, even if the only level of proof they have is that they lived in Flint. Even if the only thing they can show is that I lived in Flint, there is a way for people to be compensated. When you talk about Legionella deaths, you might think it's crumbs, and I'm not picking at you for it, but there in the settlement, folks who died from Legionella, their families can get somewhere between $1.5 and $2 million, I believe. And it doesn't have to say on a death certificate that they died from Legionella. There's actually other ways for them to show that someone died from Legionella. Does that mean that, as you put it, the poorest of the poor, or there are some folks who are not going to know how to do this? That does mean that. It does. The reality is that would be true no matter how much money it was. If it was $10 billion or $100 billion, the person you described, the person who you believe may not have access to this information or know this information, it's not the amount of money that is going to affect that person's desire or ability to be a part of this. It's the level of information, misinformation, or access to information that's going to affect their ability to be a part of it. And so, one of the things that lawyers are trying to do, and people, listen, there's a reason they tell lawyer jokes, okay? My mom's a retired insurance adjuster. My dad is a retired detective. I probably became a plaintiff's lawyer to spite my parents. There's no doubt that a lot of things that people say about lawyers is true. The reality is that in this situation, there are things that lawyers can do to help people. I'm not suggesting me. I don't care if I have any, I've got my hands full with 2,700 kids and their parents. Yes, ma'am? Was I rambling? Am I in trouble?
I'm sorry. No, I thought somebody else came on the line. I beg your pardon.
Oh. It may be my wife telling me to shut up.
You're not in trouble
in the house. It's probably my wife yelling at me. But the reality is everything you're saying has truth to it. You are not wrong. You are not wrong. But you are talking about trying to create a settlement for up to 100,000 people. Some people have no injuries other than they are just angry as hell for what they've had to go through. Some people died because they drank the water. Some kids show no effects from being exposed to lead, and other kids are already showing effects such that it'll diminish their ability to graduate from high school and go to college and reach the level of employment they otherwise would have. That is exacerbated.
Excuse me. I don't know if you're aware or not, but I got to interject this. Anytime we drink an caustic cocktail to where General Motors cannot build a car because it's rusting its part, everybody was affected by this water in here. And we're not able to defend ourselves. Now, are you accepting other plaintiffs on top? I don't want to see this kind of money come in this community and nobody get, I don't want to use the term fair share, but be left in the dark. And I know my time is up. Thank you all for indulging. I'll see you on the other side. Thank you. Thank you so much.
Thank you, Mr. Davis. That brings us
Madam Chairperson, can I just put mine?
Just a moment. Janelle, are you saying something?
No.
Oh, I thought you were. No, Mr. Stern, I believe it was that was speaking. The time is up for that round.
Okay.
Okay?
Okay, I apologize.
All right.
Yes,
that's all right. That brings us to Mr. Mays from First Ward. Mr. Mays?
Yeah, Madam President, to the attorneys. Isn't it a fact that the division of money to the plaintiffs will happen only after attorney fees and expenses?
Well, this is Ted Leopold. I will try and answer that from the plaintiff. I'm sorry?
Okay, I hope you don't waste a lot of time. I'm just asking, do attorney fees and expenses come off the top first of the $600 million?
The short answer is somewhat yes, but I wouldn't say first. I think the attorney's fees and compensation paid at the same time.
No, let's go with what I'm reading and hearing. The short answer I can go with. What is the estimation at this point, if anybody know, of the attorney fees and expenses?
This is Corey Stern. I don't think there is an estimation because in federal courts, the federal judge has to award attorney's fees. And so,
sir,
I'm not sure.
Sir, it's possible that attorney fees in the state of Michigan could possibly be 33 1/3%. Is that a fact?
That's a fact.
Okay, let me keep going and keep with the short answers, and then we'll have another round, and I'm willing to listen to y'all till the cows come home. So, let's say the judge don't go 33 1/3 and the judge go 25%. That's off the top. So it ain't really 600 it might be 500, it might be 400 million. Let's take 400 million, for example. If you got 31,000 water customers, property owners, and you got 3% for that category, and that category, whatever the documentation or proof that you did the arithmetic of 3% of 400 million? I have.
Are you asking us if we've done the math? Yes,
Yeah.
Yes, I'll give you the short answer. Yes, I believe we've all done the math.
Okay. Why can't the lawyers expose the potential numbers, hypothetical numbers, because the census tract would tell us how many people fall in a category. Do we know, for an example, already how many children were 6 and under?
We have estimates.
What is it?
The number of children who were 6 and under at any point in time during the Flint water crisis at a maximum is around 12 to 14,000 kids.
What about from 12 to 17?
Same amount. No. 7 to 11, same amount. 12 to 17, same amount. So you're talking about potentially 30 to 35,000 kids who were under 18 at the time.
I want them separate. I jumped to 12 to 17 because that percentage is 5%. And so 5% of 400 million, you've done that, and you've got the estimate of how many kids in that category of children?
12 to 14,000.
And in the 7 to 12 category, 7 to 11, how many? The same amount?
Yes, sir.
Okay, so this is how we can make intelligent decisions. Now, if you go to adults with medical documentation, or let me rephrase that, personal injury documentation, if psychologically I'm scared to drink out the faucet and a psychiatrist say that's true, is that a form of personal injury documentation?
That will be a form of documentation that would be useful to be evaluated for a damage category and recovery.
And so have any attorneys, I know you got a group doing a bone scan, have any attorneys set up in representing us any type of psychological evaluation for that personal injury category?
Yes, sir. That is in the process of being discussed. It's being sent up, and an evaluation of several doctors are in the works of trying to do that for the entire community.
So if we had psychological personal injury documentation and the number went up to 40,000 in the 15% adult category, that arithmetic can be done too. Have you done it? And what is your estimate of those dollars? Because when I do the 3% at 30,000 property owners, I come out with $630-something per person. Have you seen that?
So are you asking us to do the arithmetic based on the 20 million that's being voted on, or the 600?
No, sir. You got attorneys here that's representing more than that. And you got a community who has been given percentages, but those percentages haven't been broke down in real numbers and dollars and cents. I'm saying if attorneys know that already, can't we put those hypothetical formulas? I don't want to hear people keep saying it'll be after attorney fees. We have no idea, no clue what they are. You know how many lawyers. You can estimate it. You know. Let me finish. And then, let me finish if I may. And then you got various categories, and you know how many children, how many adults, how many property owners are in categories. Are we afraid to put out there what it could possibly be? Even though people won't sign up 100%, why can't we put that breakdown out there? Can we do that?
Can we answer it? Can you give us a minute to answer it, sir?
Sir, This is my time. I was asking a long question. You got time to answer it, and if it's go too long and ain't to the point, can I interrupt you? Go ahead. Don't waste time.
You can't.
It's something funny.
You can't. Well, I'm a little bit frustrated, sir. To be honest with you,
I'm way frustrated.
You're insinuating on the one hand that attorneys shouldn't get paid, but you're simultaneously asking them to set up psychological examinations so that people can be.
No, let me say this. I'm not insinuating that they shouldn't get paid.
Councilman Mays, who's going to pay for that? Who's going to pay for Mr.
I can answer that. I can answer that, but first let me correct you. I don't believe attorneys shouldn't get paid. I believe this group of attorneys have done a yeoman's job and been winning on almost every turn. And that's why the state and people want to settle. So I didn't insinuate they shouldn't get paid. I'm insinuating that they should get paid, adults should get paid, and the percentages should be different. And we should be exposed to the specifics. So don't put words in what I insinuate. I want you to get paid. But if you take $200 million, I want a settlement where the EPA put another $800 million. So don't insinuate and fuss at me because you don't know me and you can't read my brain. I wasn't insinuating you wasn't getting paid. I'm just trying to see, do you have an estimate of that as well?
Kids 6 and under fit into
Councilman.
Kids. Please, go ahead, Ted.
Go ahead. Yeah, Councilman Mays, I appreciate your question. I think it's a good question to ask and something that has been asked by many of us. I think that there is a process in order to do that. It hasn't been done yet. I think we're waiting for Judge Levy to make the preliminary approval to do that, but I think it's an answer to your question that should be provided. I think the hesitation about doing it now, to a little bit of perspective, is that that number may change in terms of not knowing what the take rate will be. In other words, it's highly unlikely there's going to be a 100% take rate, and it's highly unlikely it's going to be 75% take rate. But we should give the numbers as if it is 100%, or if it is probably more realistically, just based upon experience, 30, 35, 50% take rate. Believe it or not, there may not be more of a take rate than 50% of the people seeking a claim, and that's going to have a dramatic effect on what the recoveries will be. But specifically to your question, yes, it should be provided, and I think it will be provided sooner than later. We're just waiting for Judge Levy to make the preliminary approval.
And see, that's my request, because it's easy to say $600 million, and you don't subtract the attorney fees before you do the arithmetic. I got a flyer that's out there, and it says adults $115 million. They took out no attorney fees and no. I'll wait again for my next round.
Thank you, Mr. Mays. All right, we're back to Ms. Worthing. Do you have any questions?
Yeah, just a couple. So I just want to kind of state everything I've gathered from all the questions. And I had questions, but they were actually all answered, so that worked out great. So if we vote yes for the $20 million settlement, then for the most part, we will be good as far as the city obligation. Yes, we could get more lawsuits in the future, but we don't have any control over that no matter what. If we vote no, we could be out much more, and our residents would have to pay, like they did for Genesee Towers, for a water crisis that was forced upon them. Is that kind of a good, I guess, summary? If not, please
this
correct.
is Ms. Worthing. This is Rick Berg, attorney for the city. You are correct. The one thing I might say in addition is that because the city has the availability of the $20 million in insurance proceeds, it gets out of all of these lawsuits without any cost to the city. There's no out of pocket. And if the vote is no and the city goes forward and has to defend all these lawsuits, the availability of those insurance proceeds becomes very uncertain, and it has to be addressed on a case-by-case basis going forward, and eventually, could be exhausted. As I said, we're already, the insurance company is paying the limits of its policies right now.
Yes. Okay. Thank you. I appreciate that. There was something else, if I can remember. Oh, I know that Councilman Mays was talking about the $600 million. Yes, it's minus attorney's fees, but actually, out of just curiosity, for the plaintiff's attorneys, were you happy? I mean, obviously, this is what you're agreeing to, but were you happy with this amount, knowing as a lawyer, I know one attorney was stating there's no amount and you'd want to kill that person, and I think a lot of us feel that way. If our child is harmed, we want revenge. Given that we're not killing anybody and we're not getting millions of dollars each to live happily ever after the rest of our lives, is this something you were happy with as a lawyer settling for your client?
So, Corey, if I can go first, and if you want to piggyback on that. But sure, so that's a good question, and let me answer it this way. With all litigation, especially litigations as complex, as long as this, there are give and takes. And what we try to do when we evaluate resolution of cases like this is, sort of the good, the bad, and the ugly. What are the upsides? What are the downsides? And here, there is, as has been referenced, close to 100,000 people that potentially have been affected. And is it, all the money we would ever want to get for our clients? Absolutely not. If we could have got, $8 billion, we would have tried to do that for sure. But there's also limitations. Don't forget, with the state, this money is being approved by the state legislature. It's not just one person making the decision that says, okay, you can get this money. There had to be a lot of negotiations, from at least what we understand, between the governor and the Republican leaders in the House and the Senate and the Democratic leaders, and it's quite a long process. And this is what ultimately, with negotiations back and forth, the best deal that we thought that we can do, that we felt comfortable, that getting this resolved now with the state, as opposed to litigating it continuously, literally, for another 5 to 10 to 15 years, would be the best for the community. And I think that's an important aspect that everybody needs to keep in mind, is that if this case does not settle in some aspects, the community is going to be continuing to litigate this case, not for months and not for a year, but for years, plural, many years, because of appeals and all the various issues. That being said, we also know that there is additional monetary recoveries between the EPA, between the other defendants still in the case, that we feel comfortable that we can pursue those cases, and nothing's guaranteed, not 100%, but we believe percentages in our favor that we can recover either via a settlement down the road or through a verdict with those defendants, and be able to bring the same amount, if not more, of the type of recovery that we're bringing here additionally to the community. And these are all the risk benefits that we always look to in these types of cases.
Yeah, this is Corey. I agree with everything that Ted said. He's a lot older than me, so he's always a lot calmer than me. But I definitely did not celebrate the day that it settled. Anybody that settles a case at this level, both sides usually walk away without a huge smile and without a huge frown. They realize that they did about as good as they could under all of the circumstances. So I look at everything that Ted just described, and it was the exact same thought process that I had. And, the fight continues against the other defendants that are out there. That's how I feel about it.
Thank you. Actually, I appreciate that. I'm 40 years old, and I still have to tell myself to calm down and stop. I think a lot of us on council feel that way. But I thank you for your opinions. Tensions are high in Flint, of course, because we're the ones affected. And even though it's never going to be enough, I am appreciative of you saying that it could take even more years. The families that have want this settlement and need support now will be forever grateful once this is settled and done with. They deserve something for what they've went through. And my children personally were not affected, thank goodness. So I don't know if they'll get anything, and maybe a little, and that's fine with me. I want those who are affected for the rest of their lives to get what they deserve. So I want to thank you all for kind of putting us through that process of yes, there's levels. Those levels were decided based on how it would work out in other cases, in other circumstances, and I want to thank you all for being here and explaining it all to us. Thank you.
Thank you, Ms. Worthing. Now, I believe the chair made a mistake. I started on a second round with counsel, and I forgot to give the attorneys their round. So let's have a round of 10 minutes for the defendant attorneys, and then a round of 10 minutes for the plaintiff's attorneys, with anything you'd like to say.
Point of order.
Ms. Galloway?
Madam Chair, when did we do that the attorneys get a round of 10 minutes? It was limiting.
Ms. Galloway, that was my understanding. That's what I thought you requested.
No, Madam Chair, it wasn't. But
I thought that was the whole point of your amended motion.
If this helps at all, this is Mr. Leopold. I have no reason to ask any of you all any questions. We're here to try and answer any questions or concerns you have, and happy to do so. Or if you're done with us, we can sign off as well.
Okay, so the plaintiffs don't want their time. How about the defendants? Attorney?
Point of order. Point of order, Madam Chair.
Ms. Galloway?
Madam Chair, when you started with the 9th Ward council person, you started on the second round. She said she didn't want to speak on the first round. And so I'd like to finish my second round, and then we can let the attorneys go. I have a few more questions, and then they can talk as long as they want to.
Well, Ms. Galloway, we were taking it going through, okay, and as you suggested, ward by ward by ward, but then I misunderstood your motion because I thought you wanted the attorneys to each side have 10 minutes to say whatever they wanted to say, but apparently you thought, you thought they only should be answering your questions. So Ms. Wheeler asked to say something. I'd just like to hear what she has to say.
Yeah, and I want you to know that our interpretation was that we were going to be answering questions. So
okay.
We just want to answer the questions.
Okay, fine. All right, well, Ms. Galloway, I'll have to ask then if you need to go soon, whether Mr. Griggs, how would it go? 8-7. Yeah, Mr. Griggs, would you yield to Ms. Galloway because she needs to go soon on your second round?
Point of information.
What's your point of information?
Madam Chair, are you aware that I never said that I needed to go? I said I'd like my second round.
Ms. Galloway, you did say something about you just had a few questions and then you wanted to go, but I'm going to take second rounds in as they go in order. Mr. Griggs, you have your second round.
All right, yes. I've got three different questions. I don't know if best if I just do them one at a time or do all three and then wait. I'll tell you what, I'll just do them one at a time. Okay, this would be to any of the attorneys. since there are nobody in Flint has died of lead contamination. So, correct me if I'm wrong. But anyhow, I want to know what the parameters are for these children, and what are we looking for? Is a certain amount of lead in the blood test? Is that what we're looking for? Is that the only thing we're looking for? Okay, that's my question.
This is Corey Stern. That's a great question. First of all, the judge has the power to change anything that I'm about to tell you, so this is just what's been proposed. There are multiple ways that kids can get into various categories. Some of those ways are, and there's a lot. Do they have any records of lead in their blood? Do they have any records of cognitive deficits, either from their school or from testing or from a program that's been going on in Flint for a number of years? Do they have any records of lead in their bones? Do they have any records of a home that has lead or copper piping? Do their parents swear that they were formula fed when they were babies? Do they have any records of premature birth or premature birth weights when they were young? And so there's
point of information.
Just a moment, Mr. Stern. What is your point of information, Mr. Mays?
Mr. Stern, did you mean lead or galvanized, or did you mean to say lead and copper pipes?
I meant lead and galvanized. I apologize.
Okay, proceed, Mr. Stern.
My point is that there is not one way for any child to get into the settlement. There are multiple ways, and all of those ways that I just described, many of them are roads to the same category. So you don't have to have lead in your blood, lead in your bones, cognitive deficits, lead or galvanized piping to get into category 1. You could have some lead level from any of those means. You can have cognitive deficits. You can have a report from a doctor that shows cognitive deficit, or from a social worker at school. And even for children who don't have those records to prove that, or have never been tested, or didn't live in a home with the pipe that gets them into a category, or weren't formula, or didn't have a premature birth weight at birth, they still qualify for any number of categories just by virtue of their residency in Flint and their age.
Okay, thanks. That answers that question. My next question is, many of our city residents and even some of our council people thought that we could stop the $600 million and hold out for more. Is this possible?
So, again, this is Corey Stern. In terms of the vote on the $20 million, I don't think your vote stops.
Yeah. Okay. Go ahead.
I don't think your vote on the $20 million insurance, I don't think does anything in that regard. Whether you vote yes or no, I think of course there's a way for the court to decide not to approve the settlement. The court could find that it's not fair, that it's not enough, that, as Councilman Mays alluded to, perhaps category X doesn't compensate enough people in the appropriate way, and she finds that it's not a fair settlement. So the residents of Flint, the citizens of Flint who are dissatisfied, unhappy, they can voice their opinions, and even if the judge says, I disagree with you residents, I'm going to approve the settlement, then the residents of Flint can continue with their litigation if they choose to continue. So I don't think that this body necessarily has the power in this vote to hold out for more or stop the settlement. But, perhaps the citizens of Flint have the power to get the judge to deny it. I can't tell you that by her denying it that more money would be put on it. The state might say at that point in time, okay, the judge doesn't think it's fair. Let's rock and roll. Let's go start trying these cases. The engineering companies, the EPA, McLaren, they've already said that. They've not agreed to put in any money into this settlement. And so let's say all the citizens stand up and say, heck no, this isn't good. for all the reasons that Councilman Mays described or anybody else described, heck no, we won't go. We want more money. The state could just say, good luck to you. God bless. Let's go try a few of these cases and see what the values are. And I'm not suggesting that's what's going to happen or putting that out there as like, beware of that, but that's the honest to God truth.
Okay, thank you. My final point is, I just want to make sure I'm clear. On the $20 million settlement, if we vote yes, it continues to go, the settlement comes out of the insurance company pocket instead of the city. But if we vote no, that means any settlements would come out of the city's pockets and not the insurance, and the insurance would just simply walk away. Is that correct?
Sheldon Klein, yeah. The answer is that is correct. We're on our own.
All right. Thank you. I'm done, Madam Chair.
Ms. Galloway, you're next.
Thank you, ma'am. So I have a question for both of the attorneys because I think one of the questions that I have is Judge Levy's decision unappealable, final, nothing else can happen? And it's a simple yes or no.
This is Ted Leopold. It is appealable.
Okay. With that being said, the other thing, I heard one of the attorneys say that this is and I don't remember the term that he used, but he talked about the fact that the legislators and the state of Michigan legislators came to the table, to make this decision. And you guys, please forgive me. I can only identify things based on and how I try to rationalize them in my own reasoning. In my opinion, as one of only two council people that have sat on this council since the very beginning of all of this taking place, what I will say is this. The state of Michigan, in my opinion, is the reason why this community was in the situation that they are in. So I don't find it so applauding, if you will, that everybody finally came to the table and said, hey, you know what, this is a fair settlement. One of the things that we don't know is, one, the impact that this will have forever, right? And I'm sure you said that there were things you could come back and do if you, I think you said, if one of the attorneys said, if you are not a part of the settlement. But my second concern that I have is it seems like appropriately or not, however you want to word it, everything is based around lead only. We're not talking about everything else that was included in the water, the TTHM, those that might have been affected by Legionnaires. One of my colleagues said I hadn't heard anybody that was dying of lead. And that's interesting because lead has taken on a form of its own, like the life of this entire lawsuit, in my opinion. The problem that I have, and I just want to be able to say this on the record, I have a problem with the fact that the state of Michigan, the Civil Rights Commission did a study and identified, in their opinion, that this was the result of systemic racism, not just color, but class as well. And yet we're not hearing anything about that. We're only focused on lead. We're only focused on those that some deem to be the most vulnerable, and I'm not saying anything about our children, but I've talked to people that deal with the seniors, and they said that lead poisoning is similar to someone that's an elderly that might be having dementia. And so I just wanted to be able to say that on the record. But my question to the attorneys, where is the systemic racism? We are a predominantly black, or they say about 40% of our population, especially children, are under poverty. And so where is the human violation to systemic racism that was believed to be an undertone to this?
This is Corey. I mean, I'm happy to take it. The claim, so in order to get to a verdict at trial or in order to get to a settlement, either way, whatever conclusion you get to, you have to file a lawsuit and you have to be able to make allegations in the lawsuit that are recognized as legal principles or laws that have been violated. Throughout the litigation, virtually everyone who's filed a lawsuit, the lawyers who have done it for their clients, have done it in part on that basis. The lawsuits say that the state of Michigan violated various constitutional rights, that pursuant to the Elliott Larson statute in the state of Michigan, that there was discrimination based on race. So it likely doesn't feel like that if you're of the mind that this is a bad settlement and it doesn't compensate us, and I totally respect that. In order to have gotten $641,250,000, the allegations that were required to be proven, the allegations that on some level were successful at the appellate level, included those claims. I will say that both state and federal judges, for all of the successes that people have talked about that lawyers have had and why do we just not continue, the Elliott Larson claims, which are a statutory claim for race-based discrimination under state law, not federal law, state law, every judge that has viewed those claims has thrown those claims out. Now, that obviously doesn't mean the case doesn't succeed and the case doesn't go forward, because as lawyers, when we file lawsuits, we put a lot of claims. We make a lot of allegations. We do it so that if we succeed on this but fail on this, we still get to continue to trial. If we succeed on this, this, and this, but fail on this, we still get to continue to trial. But the only way that we were ever able to get to this point, whether it's a good point or a bad point, whether you like the settlement, hate the settlement, whatever your opinion is on it, the only way to get to this point included making claims fundamentally based on those principles.
And I don't want to, can I just ask you a question, because I only have 4 minutes left?
Yes, ma'am.
So the question becomes, has there ever been a case where an entire community has experienced this type of a breach of fiduciary responsibility? Simple. I don't know.
I would argue yes, and Ted could probably pipe in on cases that he's working with now. I could tell you that there was a very similar case in Washington, D.C. about a decade or a decade and a half ago that involved water that was compromised in a very similar way as the water here, and that case ended up getting thrown out. It ended up getting thrown out after years.
So if you think of it later, I'd like to know the case,
sure.
Because one of the things that is interesting, I started reading some of the transcripts early on, where it actually put in the records emails between some of the people at the MDEQ, EPA, and I'm sure, where they were saying, yeah, they recognize that they had made a mistake, but yeah, we let's just not deal with it. And so I'm not saying that there hasn't been a great effort done, but in my opinion, and I'll just wrap up with this, in my opinion, I think I find it hard to celebrate, if you will, when so many people are excluded from this. The fact that, and I'm talking about for myself, the fact that someone has a great immune system and their body was not affected. What we do know, if nothing else, is that we paid for water that was deemed poison, that was said that was poison, and we were not reimbursed. We were reimbursed a part of that. But the other thing is, there was not a doctor during the time that was willing to put anything in writing saying that some of the things that people were experiencing, miscarriages, hair losses, were the results of lead. And so it just seems like even in this, that there's still a lot of things that are left that need to be, that just don't seem fair. But as you're saying, and I'm hearing the attorneys, everybody walks away recognizing that they didn't get everything they want. And my concern is there are many people that are experiencing sicknesses and impacted by things that have no idea, but what they do know is that many of the things that they're experiencing happen after they began to consume water. And so I just want to say to the attorneys, thank you guys so. Go ahead.
Madam Councilwoman, I just wanted to say two things about what you did. This is Ted Leopold, co-lead for the class. Is what you just said, I think, is very important. The best resolution of cases is when both sides walk away thinking they gave up too much and the other side says we didn't get enough, which I think is what's happened here. And I think that means that's good litigation in terms of a result. Secondly, I am presently, you wanted an example, I am presently lead counsel in North Carolina involving a similar case involving DuPont contaminating the Cape Fear River of hundreds of thousands of, even more than in Flint, of close to 600,000 residents' homes and individuals with toxins of chemicals by the DuPont plant. And all the water system is contaminated and people can't drink the water, just like here.
Thank you.
Thank you. Sorry, I was muted. Okay, Ms. Winfrey Carter.
Thank you,
Madam
Madam
President,
Chair.
I'm sorry. Did I skip Mr. Winfrey? I did. My apologies, Mr. Winfrey.
Well, and Councilperson Winfrey Carter will be able to come up here real shortly because I don't have any questions. And some of my colleagues, a few of my colleagues asked some questions that I would have asked. I wanted to ask on my second round, but I got those answered. I just want to say to the attorneys and to my colleagues, thank you all for being here. Thank you all for asking these probing questions. And I'm hoping that our residents, our constituents have heard information and have cleared up some things. I realize that does not stop us from being called by our constituents and ask for more explanation. But I think this council person has a good handle on this case, the $600+ million and the $20 million. So I appreciate everybody. Thank you, Madam President.
Thank you, Mr. Winfrey. Now, Ms. Winfrey Carter.
Thank you, Madam President. I had a question, and I think this goes to probably our city attorney, Ms. Wheeler, Attorney Wheeler. I wanted to find out how many lawsuits are out there against the city in reference to the Flint water crisis.
If I may defer to Bill, I'd like him to give a estimate of the number of lawsuits.
Okay, and then with that, I want to find out if we can still sue. How does the settlement protect the city from future litigations? That $20 million, and I think you went over that, but maybe go over that again so that the residents can get a better understanding.
Yeah, and I'm gonna give this to you, and I'm gonna say with regards to the latter that it does give us, and I think that Attorney Klein, he said this before, it gives us a certain amount of peace in this. Obviously, there are still going to be folks who can bring their own individual litigation, but in this matter, like I said, everybody who signs up for this litigation is another person who is going to be not a part of this for the city to pay. So, like I said, every time someone signs up, that's another person who we don't have to worry about coming back and suing the city. So I'm sorry, I'm getting some feedback in the back. I'm hearing something.
You're breaking up.
Angela? Someone needs to mute themselves.
Yeah, I'm hearing something. And
there it goes. Okay, proceed.
Okay. Yes, thank you. No, but I was saying that, like I said, we are, for everyone who signs up for this lawsuit, or to become a member and become a part of this claim, it's going to be another person who's not going to be able to come back after the city later. So essentially, we're getting a certain amount of peace per se to add some closure to the city financially. And so that's really what we want, is to make sure that we minimize the liability for the city, and that the amount of attorney fees that we're paying for this lawsuit to defend, that can go away too. So those are just a couple of things. And if Bill, if you want to go ahead and chime in.
Sure. Thank you, Angela. Councilmember Winfrey Carter, I believe you asked how many cases the city is currently litigating. Is that correct?
Yes.
Look, currently we have over 100 cases that we classify as the Flint water cases that myself and Rick Berg and Sheldon Klein are working together to litigate. But within those cases, there are literally thousands of plaintiffs that are represented in those cases. Many of those cases have more than one plaintiff, and that also includes Mr. Leopold's class case. So I guess the short answer would be there's roughly 100 cases, but the kind of more complete answer would be that there are thousands of plaintiffs that we are currently facing claims from.
And so I'm just trying to get a clear understanding of the $20 million that the city is responsible for. So with that, basically, if we say yes to the $20 million, all of those cases that's out there, that would be handled through the $20 million, and I guess the overall settlement, right?
Angela, this is Rick. Can I pick it up from here?
Yes.
Okay. Councilmember Winfrey Carter, let me add to what Chief Legal Counsel Angela Wheeler said in answer to your question, and that is that all of those lawsuits will go away. And what will be left is the ability for individual people to opt out. And we can't control how many of those there are, but I think both Mr. Leopold and Mr. Stern would say that everyone should very strongly consider staying in and not opting out because of some of the reasons that they already explained, including that you're really flying solo after that. You don't have Mr. Stern, you don't have Mr. Leopold, you don't have a class action. It's you and your lawyer, and you have to find your own experts and try your own case, prove your own damages, where if you join the settlement, you don't have to do that. So there's a lot of encouragement to join, and that's supposed to help minimize the number of opt-outs. Will there be some opt-outs? Almost certainly there will be some. But for the $20 million in insurance that we've got, which again is not coming out of the city's budget or coffers, it should, everyone hopes, and the goal is that it should take care of the vast majority of the cases. For those people that feel compelled, that they just can't live with themselves, they have to go up their own way, those cases will go, those will be the opt-outs. And we can't tell how many of those that there will be. There's just no way to know that right now. There's just the strong encouragement for people to consider the value of the settlement that's been constructed for everyone's benefit.
Okay. All right. Well, thank you. Thank you guys for answering our questions. I certainly appreciate it. And Madam Chair, I'm done with my questions.
Thank you, Ms. Winfrey Carter. Okay, Kate Fields again. I really just have one question, and this is for Angela Wheeler. Not counting the time involved in your salary and Bill Kim's salary, okay, how much have we, the taxpayers, how much have we spent defending these lawsuits in legal costs? Can you give me an estimate?
An estimate. It's probably. I mean, it's at least over $1 million that we have spent, and let me tell you why. Because first, you're arguing, and lawyers, of course, highly skilled, that they're arguing a lot of legal arguments. That's the first portion of this case. The things that are in court. That can be argued before a judge. But after you get past a certain hurdle or a certain phase of the case, you're in the middle of discovery, interrogatories, your experts with millions and millions of documents that have to be researched and reviewed. So, and it's a high level of complexity. So what will happen, the benefit is that the city will no longer have to pay those costs for the litigation expenses as a result of that. Those regular expenses that we incur throughout the year, those will go away.
Okay, so I think it's quite interesting if we look at it in the case of, it's the residents that are suing for damages, for what damage is done. But it's also the residents via the taxpayers that have to pay the costs for defending the lawsuits. So it comes a point in time to me where it is a no-win situation in a certain way, and I think that's part of the reason why we are being urged to settle on this, because one way or another, the residents are the ones who have to pay these legal bills. And this is money that we have to spend in legal bills that can't necessarily be used for all of the many other problems that we have in this city. Blight, fire, police, on and on and on. So I was curious, $1 million we've already spent defending this. In my personal opinion, I think it's time to wrap this up. I think even the plaintiff's attorneys have expressed that they really feel that everybody's come to the limit of the best that can be done for the residents at this point in time. So I then go to Mr. Davis.
Thank you, Madam Chair. And I'm trying to get to the straight point for the residents. That's all my concern is this evening. I'd like to speak to the defendant as well as the plaintiff attorney again, and mainly the City of Flint attorneys, Ms. Wheeler or Mr. Bill. And this is the question. On this vote on the 14th of December, what is the best interest of the homeowners and the residents of the City of Flint when it comes to voting yes or no on that? And it's a straightforward question.
This is Angela, and I truly believe that it is in the best interest to approve this resolution to minimize and remove a lot of the liability from the city and from the taxpayers for that much, and to bring and increase that pot of money that will be going to the taxpayers through the settlement.
So you recommend it would make more sense for the city as well as taxpayers that we sign on with the insurance company, and it'll increase the settlement as well. And to me, that
Absolutely.
because a lot of people have been concerned in the community, and I've been questioning, and especially the homeowners, they've been calling me concerned about that because they're already taxed enough. And that makes good sense, and that's what we wanted to do with the question and answer session session this evening while we got all these counsels on the phone. And as well, I'd like to speak to the plaintiff attorney, and I'd like a straightforward answer if possible. How could an adult, we see the kids have got a big percent of this pie, and truthfully, how can an adult that's not signed with no attorney or no representation at this time get on board that you may not have the proper documentation, but you own or rent property in the city of Flint over the course of the period of time of this lawsuit? Where would they sign up, and how would an adult listen to our conversation right now if they wanted to sign up, get on board?
This is Ted Leopold, co-counsel for the class. And I would say that the adult that signs up now can feel assured that, one, the minors in the Flint community are being taken care of as our first line of those that have been injured, and from a medical standpoint, probably the most serious. Number two, that the adults, property owners of business, are getting recoveries. May not be all that they wanted, but they are getting a recovery. And three, that the continuation of the litigation goes on against the EPA as well as major engineering companies, with the hopes that we can get the same or more of a settlement with those entities as well down the road, hopefully sooner than later.
So am I hearing without representation, a dog going to get recovery of an attorney?
Yes, sir. As part of a class, that is correct.
Okay, anything they need to sign up for? Or do they just, because they lived in Flint?
They lived in Flint, but as soon as Judge Levy hopefully prepares and enters an order of a preliminary approval on December 21st, a registration form will go out to all the adults. And once they've signed the registration form, we will then work to begin to get claim processes in place. I want to make sure that you all understand that the community is not on an island. It's not as if this case is settled and the lawyers are leaving. We have an office in Flint. We are there, as well as I know Corey and others are, to help all of the clients fill out the registration form, to be there to walk them through the process, be there and walk them through the claims process, be there to advocate for them until the conclusion of this litigation when they get their recovery.
Can you give an address of your office or phone number, contact information?
I cannot do it right off the top of my head, but we can get that to Mr. Kim, and he can provide it to you. But our office has been in the downtown Flint community for a while. And also you can go to flintwater.com, and that's our website. So everything is going to be on the website, and also we are reaching out to people, and people can come by. Of course, with COVID, it's a little difficult, but we are there to walk people through. Last night we had a community website information session. We're going to have a webinar where people can also fill out the registration and walk them through the process when that time comes. So we are ingrained into the community to help them through the process.
And Mr. Councilman, this is Corey Stern. Our office is at 2387 South Linden Road.
2387 South Linden. I thank you all so much for this information, vital information. You know, it don't feel good. This community been struggling a long time and probably will continue to struggle on. And it's good that the fight going to continue, because people are they're concerned about the community and their loved ones that's passed and sick from this. And like colleague said earlier, it's more than just lead. There's all kinds of caustic chemicals in this water. But to begin the fight is very good, but it's horrific. All of this money coming in this community, and it's good to find out that everybody qualify for something. And also with the city of Flint, we got insurance that cover us, that we don't have to, and I'm a property owner as well. And I do not want to lose my property, as a lot of residents and constituents I represent already in foreclosure, and we're already struggling. So it's good to have a policy that will cover the homeowners without an increase of liability, even from the litigation to come down the road. So this, to me, I'm wrapping up, because to me this was a very good discussion and conversation. Very emotional for me. Got a niece that's laying in Graceland Cemetery with Legionnaires' disease. And, and other people around the community as well. But I really thank all of y'all taking out time for doing what y'all have done, the city attorneys and all the other attorneys from around the country. Thank you on behalf of Councilman Maurice D. Davis. I'm done. Thank you, Madam Chair.
Thank you, Mr. Davis. Mr. Mays.
Yeah, I want to start by saying this. I want to ask a question. Who was that attorney who said what I was insinuating? I think wrongfully. Who was that?
That was Corey Stern.
Okay. Let me say this. It's hard to communicate in a COVID-19 environment. Mr. Stern, I took a lot of slack as a council person, as a resident, when I first met with Trishelle Young and brought lawyers in. I believe she did a fine job putting people around her. I wanted to get a cut, a good cut. I helped fill up a church, metropolitan. You can't do it now because we're in COVID-19. The plaintiffs, which I am one, I had a disadvantage communicating to the masses. And so we know people are listening. And I don't like lawyers who represent me as a plaintiff insinuating how my brain thinks. That's number one. Two, what can you describe about the objection process and the comment process? The objection process can be appealed to the United States Sixth Circuit Court of Appeals. How does that work, and when do the objection process start?
So this is Corey Stern. And I agree with you, it's difficult to communicate during COVID, and to the extent that I got hot or upset, there was no harm intended, and I apologize.
Yeah, what was that about? Go ahead.
That was an apology?
No, I say, because I accept your apology, but I mean, this type of stuff wastes time, but I didn't want to interrupt you. Go ahead.
Can't object to anything until the judge either approves it, and if she doesn't approve it, then there's nothing to object to. If she grants preliminary approval after a hearing on December 21st, then she will lay out how objections work. The judge is now in control of this entire potential settlement. So I can't tell you exactly how the objection process will work. If you have a lawyer, you will ultimately choose to opt out of the settlement, and there'll be a form, I think, that you fill out that says you're opting out. If you don't have a lawyer and you're a part of the class, you will get a notice in the mail that explains to you how you opt out if you choose not to participate. And in terms of making objections, once the judge grants preliminary approval, she then has to take it a step further down the road and grant final approval. And she will permit filings, likely oral arguments, and hear from anybody that has an objection between the time that she grants preliminary approval, which just sort of turns the keys to the car and turns them on, between that point in time and final approval, which is when the car would reach its final destination. She will lay out the procedures for how to object.
So you can't say whether or not you have to opt out to object. You said after the preliminary approval, if it's granted, then. But you saying the people who opt out. Can people who have not opted in or out object?
Yeah, there's a period of time between now and December 21st where there are a number of individuals who are filing responses to the motion for approval, and there will be oral argument on that on December 21st.
Exactly, but I don't want you to mislead people that only people who can opt out and object. And we had good lawyers. I hear you saying we had to go get other lawyers because our lawyers who was representing us and our specific concerns been settled before we got to a certain point. So we had good lawyers. Am I understanding that for those who opt out, and if the EPA goes to trial, those people is out of it and can't even go to trial with the EPA and the others who haven't settled? Is that what you're saying? We got to get all new lawyers, but y'all saying, and it's confusing, that we're going to continue to litigate with the EPA.
No, Councilman Mays, that's not correct. The EPA is a different case because in the EPA, those are all individual cases, and everybody has counsel, and it's a separate litigation in front of at least most all the cases are in front of a different judge, Judge Parker. So that's a different, totally entire separate matter. So that is,
and that might have something to do with why they're not included in this settlement.
That is correct. That is correct.
Okay.
And without speaking out of school, you know, we do have a new administration coming into Washington, D.C., and I think some things may change as well. So, you know, there's things that are happening. But
and that's what I want.
Separate litigation.
And that's what I want, Ms.
Yes.
And that's what I want Ms. Fields to understand when she talk about suing yourself and taxpayers paying. The theory, Ms. Fields, is City of Flint is a governmental entity. The state of Michigan has more money than the city of Flint, and the federal government have more money than the state. And we pay state taxes, federal taxes, and local taxes. But when you mix 300 million people's taxes together, that's why the taxpayers do pay, but it's a way to do it. And so I don't want people to buy into that. We suing ourselves. I got that criticism when I start hosting lawyers and bringing them in and helping pull people in droves. I was disappointed because when they come in and want you to set up town hall meetings and bring people out, then when something this big comes, my phone ain't rung once. Now, let me say this. The objections, you saying we have to get a lawyer because the lawyers who we got, some of the best ones, who some people think I don't want them paid. I want them paid, but if it costs the state, the EPA, 200, 300, 400 million, give it to them. If the formula ain't clear to me, whether they get 200 million, 300 million, 20%, 33%, you got to know that when you do your adding and subtraction to see what's left. I look forward to those hypothetical details of category and the exposure to this community, which you might not want to do because I heard you say businesses. That's a 2% category, correct?
You might be correct. I just don't recall the number off the top of my head.
Oh, I do. 2%, 3% for, beg your pardon?
I said you may be very correct. I don't have the paperwork right in front of me. I just don't want to misspeak.
Yeah, I've been having this paperwork and looking at it and been on my calculator and knowing how many people is divided on, and I want the community to know. Because in my opinion, the more people who say it's not fair, I understand the risk. We've been understanding the risk for so long, but Judge Levy and the way this thing is being presented to the community in percentages, it's even flyers out mixing the 3% with the 15%, putting figures out there that ain't even subtracted attorney fees is very misleading to this community. And so one way or another, beg your pardon?
No, I thought you were done. I'm sorry. Go ahead.
So one way or another, my job is to get specifics out and to show people hard line what they are opting in or out of. And I don't want to frustrate attorneys because if attorneys have worked hard, did a good job, and they think it's time to settle, they should be sharing with us hypothetically what they think or what they're asking for. I don't know. I don't know how many attorneys, what they're looking for, and it seems discouraging to me that attorneys will just say, hey, get a new attorney. Get a new attorney. Now, when you get a new attorney, they will be privileged to all of the things y'all done already won, correct? Because it's there. It's in the record.
Well, it's part of the record. That is correct, at least from the pleading standpoint, not experts and things of that sort. That's totally separate. But I do want to comment on one thing you said that I think is very important, and I agree with you on, and I'm sure you agree with this, is knowledge is power, right? So we want to make sure we get all the information to everybody, and we're endeavoring to do that. You know, this is a big process, and there's a lot of people.
And knowledge. And I'm trying to use my time wisely. Knowledge is power, even when you ask attorneys specific questions in a public setting. Knowledge is power, and the more detailed knowledge on these settlements and the division of money, that's power to the people so they can make legitimate decisions. Now, isn't it true that children, may I wrap up? Because this is ridiculous. My colleagues don't have questions. I do. I have questions, comments. Is it true? May I wrap up? Is it true? Is it true that all categories of children, has been said, documentation or not, they should get some type of compensation? That's a fair statement.
Yes.
On personal injury, but that's not true for adults. Adults must have personal injury documentation, different from the children's category, correct?
I'm not sure that's true. I don't think that there has to be documentation for every category.
In the 15% category, personal injury is in the 15%. The property in the 3% is a different documentation. I know y'all know what I'm talking about. Let me ask this final question, and then if they allow, if they ain't got no more communications, maybe they'll let me go. But now, is that money, monetary damages, going directly to the parents and kids, or is it going in a trust fund?
This is going into a trust fund. It's not necessarily going into. It's not necessarily even going into a trust fund. Parents or guardians can make a selection for where the money goes. It can either go into a trust, or it can go into a structured settlement, or it can go into the registry of the court. But that's not because of something that was negotiated in the settlement. It was because what the rules and probate laws are in Michigan for people who are under 18.
So these children, who is a big bulk of the category of compensation, them adults who done took care of them, who done nourished them through this, because they hooked the kids or children, they might not touch nothing, and they still have to continue to deal with these children into a time certain.
That's because what the law in the state of Michigan requires to protect children from people utilizing money that's theirs either by way of a settlement or a lawsuit. So you may think it's the worst thing in the world, and some people may agree with you, but there's a state legislature that made that law many years ago.
No, I don't think it's the worst thing.
Mr. Mays.
Let me say this, Ms. Fields. I'll say this and I'll be done. It should be a category for them adult parents, and that's the percentage breakdown we're going to need to get to make this fair for what's happening now as they grow. But let's see what happens before they dismiss y'all. If they ain't got questions or communications, I do. Let's see what's happening. Thank you so much.
Madam President, this is Ted Leopold. Madam President, this is Ted Leopold. Can I give the address? I have it now.
Yes.
That was asked to me earlier. It's 1188 Robert 1188 Robert T. Longway.
And that's your address?
Yes.
What address is that? Okay. All right. Thank you, Mr. Leopold.
1188 Robert T. Longway.
Thank you.
And the phone number is 866-836-0717.
Thank you for that information. Okay, now I'm going to start the third round. If you have no questions, please just say, I pass. All right, Ms. Worthing.
I pass.
Mr. Griggs.
I pass.
Ms. Galloway.
All set, thank you.
Mr. Winfrey.
I pass.
Ms. Winfrey Carter.
I pass.
Kate Fields, I pass. Mr. Davis.
Thank you for indulging, Madam Chair. I'm good, but I just want to make this quick statement because this is a public record and a public venue win. I'm thinking it's best for the residents, and I don't put words in their mouth, but the homeowners especially, we need to accept this insurance policy to get the city out of trouble as well as our tax increases out of trouble. And we go from there, because my clarity for the residents that may not be as thorough as we are, we can't change none of this settlement. So I don't want the residents to be confused by what's going on in the streets. We're not here discussing, as far as I'm concerned, the settlement. That's in Judge Levy's court. But we need to understand this. We can opt into this insurance policy on the 14th of December and get us out of harm's way for all this litigation that's going on, so we won't be taxed out of here, gentrified out of here because of tax increase. And we have attorneys, they gave numbers, and I will put it up as soon as I get the information, how people can opt in or get on board with this train that already left the station. It's already been filed in federal court, and we can't change one iota. Is that $641.2 million, and if I'm wrong, this is the proper time for a city attorney or either a defendant attorney or a plaintiff to correct me. And thank you for indulging, and I'm out. I tap out. Thank you, Madam Chair.
Thank you, Mr. Davis. Mr. Mays.
Yeah, I'm not a city attorney, Mr. Davis, but I would say if you got 20,000 people filing objections and objections talking about the particular categories and the amounts of money, that's what the objection in the process before the judge is. If you got people believing they covered in a certain way and happy, and they hop on with attorneys and the judge see that, then you might get her to agree to settle. But if this community talks specifics, dollars amounts, percentages and categories, and have a good lawyer, just as these good lawyers, it's a chance that she might look at whether it's fair. And then if she don't agree, then you can still hold it up and appeal to the Sixth Circuit Court of Appeals. That's how we got here. We are resilient. We are educated. We are intelligent, some of us, and we will fight for the least of them. The least of them that would be the ones that's getting the at this point. So if the EPA is in another court, is that what people keep saying? More money might come in, or it won't come in through that? Are y'all talking to try to settle that in this with the same percentages in the same division, or y'all will continue to represent us with a different percentage? Do you know?
I'm not sure I understood that question. Could you ask me that one more time?
Yeah. I'm hearing you say that Judge Levy's court and these percentages and settlement and this pot of money is Judge Levy. Then you say you got another court over here with another judge, and they're separate. Are you anticipating that the settlement from the EPA and that proceeding might come into this, or you are feeling that it's going to go to trial? Or if it don't go to trial, will all the people who opt out of this still be in that?
Well, without getting into what I would refer to as attorney-client communications and thought processes, the only thing I can tell you is that the EPA cases, since it's against the U.S. government, attorney's fees are capped a certain percentage. So no matter what kind of percentage we'd want, we are only limited by what the federal statute allows.
That was not my question, though. But
Mr.
let me see if
let me try.
Okay, go ahead and try.
The EPA, the cases against the EPA have literally nothing to do with this settlement. So even if someone participates in this settlement and they have a case against the EPA, they are not relinquishing their case against the EPA. If there's a settlement with the EPA hasn't offered, as far as I know, a single dollar yet. It is too late for the EPA, as far as I'm concerned, to join the current settlement. Any new settlement with the EPA would be separate and apart, brand new terms, new negotiations, and if individuals take this settlement but have cases against the EPA, they can continue those cases. If they don't take the settlement, they can continue against the EPA.
And y'all will continue to represent each and every one of them as moving forward.
1,000%.
Okay, that needed to be cleared up. I appreciate you understanding that question. So when people say more money can come in, did you just say it's kind of even too late for that?
In terms of joining the settlement that's already been filed, it's hard for me to imagine a scenario where a negotiation and an offer and an acceptance could take place between now and December 21st in light of what I've already known about the EPA, Veolia, land, and the banks who I recently sued. I would bet a significant amount of money that matter to me that they cannot get into this settlement. It would have to be new. It doesn't mean it can't settle under different terms.
I understand. Now, is the attorney named Mr. Berg on the line?
Yeah, Mr. Mays, this is Rick.
Mr. Berg, you said earlier in the meeting that you helped write the intent to sue letter for the city as it relates to the intent to sue the state of Michigan, correct?
I did help to write that letter.
Who helped with you? Was it any local lawyers I know?
Well, it was Mr. Kim, who is with the city law office, and it was my partner, Sheldon Klein. So actually the three people that helped write it are all on the phone together.
Okay, and when y'all wrote it and filed it, did you believe in it?
Well, yes, we believed in it. Sure, we believed it was the right thing to do.
And the city was billed time for that. Why after month after month, year after year after I asked about that, why we didn't sue the state to keep the liability off of us versus now everybody talking about $20 million in the city, $20 million. Why did we not file a third party or a counterclaim against the state all this time? The letter said there. Why did we not file it?
Well, in March 2016, when we sent the notice of intent to sue, we had been on the case maybe a week. And after that, as we learned the facts and got acquainted with the law as it applies to the facts, we investigated what our options were. And we did that at great length. And ultimately concluded that because Michigan ultimately has immunity from most claims, that we were not going to be able to succeed in a claim against the state. And that's true. That's been true for many things. The defendants in the case that are in the state are the employees of the state. And the claim that has been successful, the claim that has survived the trips to the Sixth Circuit and the Supreme Court and back down again is called invasion of bodily integrity. Well, as a city, we don't have a body. We didn't get lead poisoned. The claims that people can bring are different than the kinds of claims the government can bring. And so we just were not the kind of plaintiff that could bring the same kinds of claims that the plaintiffs that Mr. Leopold and Mr. Stern represent can bring. So it would be not only a waste of time and money for the city to pursue the state, but it would be it would ultimately reflect poorly on the city for bringing claims that were not legally defensible. We're not legally provable from the beginning.
Remember, all night we've been talking negotiations and settlement, from lead pipe replacement to water credits. We've been able to negotiate settlements where the state and the federal government took care of the city. So I would just be of a different mindset. I might not would have sued them in a counterclaim for bodily integrity type claims, but believe me, law is creative and settlements are negotiated at some time before trial in some cases. So I just wanted to put that on the record. The $20 million, I'm straight on it. But under COVID-19, when I'm trying to communicate to 40, 50, 80,000 adults, and I hear them not getting the whole story, not getting the devil in the details. And when I got lawyers reluctant to tell me, and I'm not saying y'all have done that, because I'm going to look forward to a spreadsheet. Estimated attorney fees, estimated number of people in categories, estimated amounts after attorney fees, and let the community see that and give us a real reason to opt in or opt out. I was glad to hear a figure of maybe $1 million, $1.5 million for folks who might have died of Legionnaires. I got a cousin who lost legs at McLaren. He believed he should get the whole $20 million from McLaren. I don't blame him. I want my legs. But the point is this. You had, and I'm glad to hear the other deaths. My mom died of respiratory issues right down the street from Mr. Davis's niece, who we was on a PBS Frontline special. I don't want grown folks, the voting population. I mean, kids, I love them. I'm going to protect them, and I'm going to make sure their money is right, and I want their parents' money to be right. These are the people I represent, the voters. And I'm telling you, grown people pay taxes, grown people pay them water bills, grown people should not be embarrassed by getting a check for $600 if my arithmetic is correct. I hear that buzzer, and I'm telling you, this 10-minute thing, we got to do better as a council. If you listen to the details of the questions, if you listen to the trying to share knowledge publicly, and you can't settle this stuff, you can't get a good understanding in 5 minutes, 10 minutes, I appreciate it. Maybe we can do it again. Maybe my phone will ring. But whether my phone rang or not from attorneys who represent me, maybe the attorneys will figure out how to do. When I was in California, it was a question and answer period.
Mr. Mays,
that was
Mr. Mays, could you please wrap up? You've gone past your time.
Yeah, Ms. Fields, I can. But when you got so many council people passing, and satisfied, and you got certain dialogue going, that's the problem in this city. That's one of the problems. I'll figure out how to do it. I'm a politician. I'm an activist. I come out of that movement. I'm an elected official. I'm a trustee. I'm a plaintiff.
Mays, you're taking more than the agreed upon fair time. Please wrap up.
Only when other people, the purpose was if other people had specifics, Ms. Fields. I'm straight. I know how to communicate to people. Let me finalize with this. How long can y'all get me that spreadsheet where we go down in the specifics, a number of people in each category, possible attorney fees, and the possible amounts? When can we see that spreadsheet come to light for the community?
As soon as the special master and Judge Levy allow us to do so, we will do it.
So,
okay, Mr. Mays,
are you familiar with the proceedings that know when
Mr.
we could
Mays,
maybe?
Please, you have gone way past your wrap-up time.
Ms. Field, not really, but this is important, and you are really being a stickler as a chair.
You're out of order, Mr. Mays. Please. Are you finished?
No, I'm not. This is too big to finish. I'm just responding to you because you unlawfully mute me, throw me out. I'm suing y'all.
That's your first warning. That's your first warning.
Okay. Appeal the ruling of the chair. You asked me a question. I answered. I appeal your ruling that I should get a warning for answering your question. I had got quiet. You asked me a question. I appeal the ruling.
Is there a second to Mr. Mays' appeal? Is there a second to Mr. Mays' appeal? Is there a second? The appeal dies for lack of support.
Madam Chair.
Mr. Davis, I had already asked 3 times, and I'd already announced that the appeal died.
You didn't hear me.
Point of order.
For lack of support.
Point of order. Point of order, Madam Chair.
What is your point of order, Ms. Galloway?
Madam Chair, he did say something before you announced. And you didn't
hear him.
I know you did.
No, I did not hear him.
But
all right,
Mr.
Davis. Well, I can only go by what I can actually hear, Ms. Galloway. But I'll give latitude if Mr. Davis wanted to second that appeal. It's been moved. The appeal has been moved and seconded. Okay, now discussion. Mr. Mays was out of his time. I didn't stop him. I didn't even tell him to wrap up. He talked for another minute, 2 minutes. Then I told him to wrap up, and he kept on. And when I asked him to please stop, he was going beyond the time we had asked for. He argued with me. And I gave him a warning that he was out of order and that because that wasn't what we had agreed on. And Mr. Mays started talking about something totally unrelated when he was wrongfully removed his chair, which wasn't relevant to his time being up or relevant to his warning whatsoever. So, is there any other discussion on this appeal?
Yeah, Madam President.
I heard somebody else first. Was that Mr. Griggs or Mr. Winfrey?
Davis.
Davis, sorry. Mr. Davis.
Yeah, I just want to say, Madam Chair, on behalf of my colleague, and like I said, this is very important to this community. What's going on this evening is unprecedented. He's on the phone. Everybody exhausted their questions, and it seemed to me Councilman Mays got a few more questions to go. I think it's only fair to indulge him the next 15, 20 minutes, then we just wrap up this meeting and we out. Because, he asking stuff that's important to him and his constituency. So, it ain't like somebody else waiting to get the floor, and if it is, give him the floor and then come back to him. That's the agreement. I thank you for indulging.
Thank you, Mr. Davis. Would anyone else like to have discussion on this appeal? Was that Mr. Mays?
Yeah, Madam President, I think if you review the record, I heard the timer go off. I think these are important questions. I heard my colleagues say they was all set. That's why we established 10-minute rounds. That seemed to have not happened on this last round. Nobody had questions, and so we had saved a lot of time. And I'm glad that I was indulged a little bit to go over, but that was the record of show that I got quiet. You asked me something, and I came back in. And when I came back in talking about how you conduct meetings with me, I can't speak for either the Worthing and Griggs or nobody else. With me, that's what the record will show. I have to struggle to stay in these meetings in an intelligent way. You shouldn't have to be burdened with that. And so when then you took it to a warning, your style with me is very well documented. I appealed it. Win, lose, or draw, I appreciate this time with the attorneys. And if the round went again and nobody said nothing, 10 minutes on such important issues, and us being a council with people listening. That's the beauty of it. People listen and we learn. That's what we were here to do. And so from beginning to end, this is about your third or fourth meeting, you are being a little too much. And win, lose, or draw on this appeal, you need to be a little more considerate. Be a little more considerate and logical, because it's already, nobody else had nothing to say unless you went around again and they said they didn't have nothing, and then Mr. Davis said something, I said something, and we wrap it up. I'm about tired of dealing with this tiptoeing, trying to be a councilman with you in that position. And maybe it's a cultural difference. I'll be both no on my first warning, and then after this, I wouldn't care if it adjourned, because you was a little too much. It's embarrassing.
Would anyone else like to speak on this appeal?
Yes, Madam President.
Ms. Worthing?
First of all, the appeal is on the first warning, and Mr. Mays was talking over the chair. He was asked to stop, and he didn't. And I mean, this is a no-brainer. I'm going to be voting yes with the chair. But also, to Mr. Davis's point, we did not agree to have all of our time that we don't use to go to any specific member. So Mr. Mays may think his questions are important. You may think his questions are important, but not all of us do. And this is the third time we've had this meeting. This is the third. And I think the attorneys have been wonderful and have answered all of our questions. It's not fair for any other member to monopolize time, and maybe they can call somebody to get any more questions answered. But it's absolutely not fair to continue this meeting and let one member dominate. Thank you.
Thank you, Ms. Worthing. Would anyone else
Point of information. Point of information. Do Ms. Worthing realize I'm doing this to help educate our whole community, not just me?
If I can answer?
Madam President. Madam
Just
President.
a moment. It was a point of information. Let Ms. Worthing answer.
Yeah, we've already asked our questions so that everyone can hear, and I think that there's 9 of us who are very intelligent, and we've already, all except for one, have gotten the answers we need for our constituents.
Are you through, Ms. Worthing? Are you through, Ms. Worthing? Okay, Ms. Galloway, would you like to speak on this appeal?
Yes, Madam Chair. Thank you so much. Madam Chair, my concern is you asked Councilman Mays a question and then he responded, and it seems like you gave him a warning to that. But I just want my colleagues to recognize that no matter how we feel right now, our rules govern our emotions too. And our rule, the one that we voted on at the beginning of this meeting, was that each council person would be given 10 minutes and we would continue to go around, and that there would be no limit on how many times you can go around. And so I think that we have to be governed by what we voted on. And so if in fact, Madam Chair, if in fact the simple remedy would have been to ask anybody else if they had any more, but my colleagues don't get to decide now that because they've gotten all their questions answered that nobody else gets to speak. I don't know that I would want to be here. And so I don't think that the warning was fair. Everybody was finished. And I just want to make sure that we simply go by what was voted on. And what was voted on is we will continue to go around until nobody else had any questions. And that hasn't happened. And now we're trying to change that. And so I'll be supporting I won't be supporting the chair in this matter.
Are you through?
I am. Thank you, Madam Chair.
Would anyone else like discussion on this appeal? No? Then I'm going to point out something. I was chairing according to what this body voted on in that motion, was that we would have 10 minutes. I gave Mr. Mays a lot of latitude in his wrapping up. He recognized he heard the bell when it went off, and he continued to talk for 2 or 3 minutes. Now, if I had let anyone else on this council, ignore their bell and just keep talking, even though they'd been asked to wrap up, and then start arguing with me when I was saying your time is up and it was time to move on to something else, I would have heard from several quarters. So Mr. Mays is not a special case. If Ms. Worthing
point of information.
Galloway, what is your point of information, Mr. Mays?
What do you think would have happened if I had gave you the finger and said F-off? You did that,
Mr. Mays,
didn't you?
You're out of order. That's inappropriate. And I shouldn't even have recognized the point of information during an appeal. but that's inappropriate. If Mr. Mays wants to speak again, he would have had another opportunity. I would have asked for another round, or I would have asked for some motion at some point in time to perhaps limit debate, since over 2/3 of this body has said that, they have no more questions. I mean, Mr. Mays has incredible stamina. He may want to talk and just talk in a soliloquy for 2 more hours, and if the body wants to let him to do that, well, then the body wants to let him to do that. But the fact is, I was applying the rules. And Mr. Mays got argumentative with me and was refusing to go by the chair's ruling. And there is no special rules for Mr. Mays. The rules are the same for everybody. And he tries to argue against it, and Ms. Galloway, you try to support it, and you're saying we have to follow the rules, and yet what you just said actually is exactly against that. The chair ruled according to what we had voted on, and Mr. Mays got argumentative and wouldn't stop talking. So I ruled that he had a warning because he was out of order. So, roll call. If you vote yes, you agree with the chair. If you vote no, and did somebody say something?
Yes, President, I was wanting to say something. I've not had the chance.
Well, Mr. Griggs, I'm going to tell you, because this has happened now a couple of times, all right? I will gladly give you an opportunity to speak on the appeal. Gladly. But when I say, is there any more discussion on the appeal, if no one says anything, the chair in an appeal speaks first and speaks last. So I wouldn't have spoken if you had spoken up, but you can't ask after the chair starts speaking for the last time.
Actually, it's a point of information is what it actually is. I don't know if I can I even
Well,
say
there
that?
isn't supposed to be a point of information during an appeal, but since I allowed Mr. Mays to have one, I will allow you to have one. What is your point of information?
All right. It's through you to Ms. Wheeler. I'm assuming that these 3 attorneys are being paid by the hour right now. And it's probably at least $1,000 an hour. Is this correct?
Point of order.
Madam Chair.
Yes. Mr. Griggs, rather than deal with this attempt to obstruct and create chaos, okay, I'm sure your answer is yes. So I'm sorry, I'm not going to ask Ms. Wheeler to respond. I'm just going to go to the vote on the appeal. If you agree with the chair, say yes. If you don't, if you agree with whoever called this appeal, Mr. Mays or Ms. Galloway, one of them, you agree with them. So roll call, please.
Ms. Fields?
Yes.
Ms. Winfrey Carter?
No.
Mr. Winfrey?
No.
Ms. Galloway?
No.
Mr. Griggs?
Yes.
Ms. Worthing?
Yes.
Mr. Mays?
No.
Mr. Davis?
No.
Vote is 3 yes, 5 no.
3 yes, 5 no. So the chair's ruling, the appeal wins, the chair's ruling fails. Well, at this point in time, I'm going to tell you that based on this vote, since this body is, at this point in time this evening, not willing to go by the rules,
Point of order.
willing to say that Mr. Mays
Point of
can
order.
have whatever rules he wants, then
Point
Mr.
of
Davis,
order.
I'm turning this over to you. Good night.
The president is out of order at this time. The president needs to do something with that. And laughing, who's that laughing? Janelle?
Yes, sir.
Okay, the meeting going to continue, but this is way out of order, and the president was clearly out of order. Clearly out of order.
Mr. Vice President.
Yes, Councilwoman Carter.
I think she left the meeting on to you.
Yes, and
yes, she got
we're
a little
continue.
frustrated and left.
Okay, and we'll handle it from there. But
Mr. Vice President.
Councilman.
Yeah, Mr. Vice President, let's see if we can thank those attorneys. I'm very resourceful. I know how to get answers. I know how to communicate publicly to people if need be. I want you to see what other colleagues want to do. But as it relates to me in this meeting, I really appreciate them. I understand everything that was said. A couple glitches, but just so you know, that's where I'm at.
Okay, Councilman.
Mr. Vice President.
Yes, Councilwoman Galloway.
I want to thank the attorneys too, and I want to thank my colleagues. One of the things that this is a reminder to me of, when here we have the council president and we have a body, and 5 people on the body make decisions, not one individual. And this reminds me of a repeat of when we had a similar situation when President Fields was the finance chair, and when a vote of the body resulted in a decision that she didn't agree with, she resigned as the chair of the finance chair. And so I just want to say to all of us, there are votes that we don't agree with, but we can't just quit on the residents when that happens. And so thank you, sir. I look forward to continuing this meeting. It sounds like we're moving on. Will you let us know where we are?
Yes, I will. Janelle, I need to know who all do we have a quorum and who all still present.
Everyone is still present except Ms. Field.
Mr. Vice Chair.
Yes. Who's it?
This is Corey Stern, one of the attorneys. I just wanted to say to you all. I just wanted to thank you all very much for giving us the opportunity to talk. I know that everybody has different feelings about all of this. I've been on this call since 5:30, and we're living during a pandemic. We have everything that's going on with the national election, and it's as long as this went, it's nice to see kind of democracy working and Robert's Rules of Order and quorums, and just y'all treating this with a level of kind of respect and dignity and care that I think a lot of people don't realize happens on a daily basis in cities across the country. And I'm not saying this gratuitously. It's just, it was nice to participate in something like this, irrespective of the outcome or whether my participation helped or hurt in any way. But honestly, it's something I wish my kids could have listened to, and y'all should be very proud of the work that you do.
Yeah, and this is Ted Leopold. If I could just echo what Corey says, and thank you for the opportunity. And I know we all, and I mean this sincerely, all of us are trying to do the best for the community, and I know you all are as well. That's why, like Mr. Councilman Mays and others, want more information is better. As I said, knowledge is power. And I'll end on a happy note and leave the call from here, but at least Mr. Stern and myself, the council will know, are happily not being paid by the hour. We're here out of gratis, so no need to worry about it at all. It's been our pleasure to be on the phone and answer your questions.
But I already gave you my address in Flint if y'all want to send me some cash.
Thank you so much. Thank you so much.
Mr. President, Vice President.
Councilman Mays.
I don't know if they done, but when you hear words such as that, and you look at this demonstration, what we had here today, and we know people is listening, I just want to send them on with, sincerely, God bless you. We love you. We love what you're doing for Flint. We don't have to agree. We can follow the legal process. Some will opt in, some will opt out. It's been a pleasure, and it ain't over. I mean, y'all ain't going nowhere. So God bless you, and, it was interesting and a good meeting. Thank you so much to y'all, and I appreciate my colleagues. We know our politics. So thank you, Mr. Vice President. I want to put God in it after I heard those words.
Absolutely. Any other remarks on this settlement? Yes.
This is Sheldon Klein, one of the counsel for the city. I'm guessing that you'll be leaving in a minute. I just want to make a small point, other than to thank everyone like the others. There was discussion that the court was going to be holding a preliminary settlement approval hearing on the 21st. That will be accessible by Zoom. I don't have specific contact information at this time. Now, this isn't the opportunity to object. That's going to come down the road. But if you want to spectate and watch what's going on, I don't imagine they can handle thousands of people, but there will be an opportunity to look in and listen in if anyone is interested.
Thank you, Attorney Klein. Thank you. Anyone else? Attorney Wheeler, anyone else like to make closing remarks?
I'll just say again, thank you for allowing all the attorneys to be on the call tonight to answer your calls. And I just wanted to say thank you for that and thank everybody for their time.
Thank you, Attorney Wheeler. Thank you so much. And it's vitally important to this community to have this discussion this evening so 14th we can make an educated choice and do the right thing for the community as well as the city. So I'm sure the residents should appreciate this discussion this evening. And I guess we'll move on off of Resolution 200488, and we're down to liquor license, or am I wrong?
We are on additional discussion items, Mr. Vice President.
Okay, good. Thank you for bringing me up to speed. Any additional discussion items at this time?
Mr. Vice President.
Councilwoman Galloway.
Thank you, sir. I did have an additional discussion item. According to the charter, and I'm sorry, I just misplaced. What did I do in my charter? According to the charter, in the 7th section, as it relates to the city's budget,
yeah,
there's supposed to be a presentation. And give me 1 second. Yeah, here it is. Sorry, give me 1 second. So, according to Section 7-101 of the budget, number 4, on or before the first Monday of December, the mayor shall submit a preliminary budget to the city council for the next fiscal year. This preliminary budget shall also be posted to the city's Flint's website and be available for public review at the city clerk's office. The budget shall align with the city of Flint's strategic, comprehensive, and capital improvement plans. The mayor shall present to and receive input on the preliminary budget from the city council no earlier than 10 business days after the presentation of the preliminary budget and no later than 20 business days after the presentation of the preliminary budget. The mayor and city council shall hold a public hearing to receive input on the preliminary budget from the public. The notice for the hearing to be published in a newspaper of general circulation or as otherwise provided by law shall include notice to the public that the preliminary budget is available. And so through you, is the mayor on the line? Okay. Then through you, is Clyde Edwards on the line tonight? So
this is Clyde Edwards. I'm on the line.
Clyde, do you know if, in fact, we are scheduled to have, now we're on Thursday, so the only time we can have a meeting is tomorrow or Monday according to the charter so that we're not in violation. I was just wondering, are you aware of where we are on that preliminary budget?
Councilman, Councilwoman Galloway, I would say at this point in time, let me look into the issue. I was here to listen to what you were dealing with in terms of the water litigation. So your question sort of comes at a strange point at this time. So I would ask that you allow me to look into the situation so that I can give you a proper response at such time.
That's perfect. And just so you know, Clive, I don't know what you mean by strange. I'm just reading the charter, and as you know, there's been some litigation against the city for charter violations, and I'm just trying to, I thank Councilwoman Fields because she made sure that number 3, on or before the first Monday of September, the City Council shall pass updating the strategic plan, and so I'm just trying to maintain alliance so that we as a group of leaders would be just looking at that part of the budget. I know that this has been a very tough year for us. COVID, I was on a webinar, I don't know if you call it a webinar, where actually Eric Scorzoni and some of the leadership in other communities was talking about how challenging COVID might actually affect the income taxes that we collect, considering that the city of Flint is one of, I think, 23 municipalities that collect local income taxes. And with so many stay-at-home, they wouldn't be working in Flint. And so I look forward to hearing from you on that matter. And so, Mr. Chair, that's all I had.
Thank you, Councilwoman Galloway. Okay, I guess.
Mr. Vice President.
Yes, Councilman Mays.
Yeah, Mr. Vice President, on additional council discussion, I moved around as best I could because repeatedly since March to now December, March, April, May, June, July, August, September, October, November, December, I count 10, but I say for the last 8, 9 months or more, I've been trying to go according to law and ask the mayor to live up to the state of emergency law, 14-1 to all the way to 14-17 and 19, and convene expediently in a reasonable amount of time to discuss COVID policy. My information tells me from March to, say, October, the city of Flint, the essential workers mandatory had about 30 cases. In the month of November alone, 25 cases, total of 55. I'm going to let others report, was there any deaths? So I take it very seriously. The charter is law. Ordinances is law. So I don't bite my tongue no more. Our job is to enforce the law, apply it equally to all, and to look out for the public health, safety, and welfare of our residents and our employees. I'm going to ask again that the mayor live up to the law, quit going week after week, month after month, avoiding the legislative body. I want this legislative body to be what it is, by law. This legislative body should inquire. It should hold appointed and elected officials accountable in a reasonable and timely manner, particularly when we're in a pandemic and employees are at risk. For example, I've articulated week after week, month after month, if we can set up testing at churches and places that is closed, and I'm highly respectful of my church and all pastors, and pastors don't study this charter and the law like I do, and I don't study and know the Bible like they do. So you can trust me as a political elected leader. I'm not being funny or nothing. We should set up testing. I know they say the vaccine is on the way. It's coming to essential frontliners. So to make my point again, not only is the mayor derelict in his duty, but those council people who have repeatedly for months not did what the charter and the law tells them to do. When we want to summon somebody, every legislative body from the United States Senate to Lansing and here locally. So some of us, are just as derelict in our duty as it relates to this COVID-19 state of emergency, the public welfare, safety of our employees. And I'm saying, shame, stand up, do our jobs, just like we refuse to go in private and talk to them attorneys in executive session, and look what a joy people learn. We need to not be privately talking about the policy, the opening, the closing, the testing, the who worked here, who worked. This should be a public conversation as dictated by the state of emergency law of the city of Flint. So shame on those who have said over and over, like, we don't care if he live up to the law. I'm not going to subpoena him. I'm not going to be, and that's why I said, Mr. Winfrey, I guarantee you 100% between me, you, and God. I'm not kowtowing nobody. I'm just trying to do the oath of office that I took to live up to my job and to look out, particularly in an emergency. This is my second emergency, and that's why I was telling them attorneys, y'all heard me. I took a lot of criticism bringing lawyers in to try to sue on behalf of these people. And I'm not going to let 30 or 40,000 adults think they covered. I know they could be covered. And if you give them 5,000 apiece, that's another 500 million for 30,000 people. I done did the math, and I want to reveal something, not only about that settlement, but about the coronavirus and how to stay safe. I'm blessed to be able to have meetings by phone, stay at my house, and Davina, Jennifer, and our staff, and Janelle, I pray to God that we all get through it. And for all other employees, family members who hear me, I'm going to speak, I'm going to fight, I'm going to protect loved ones. So I want this on the next discussion item meeting agenda, because remember, when they threw me out, in my opinion, wrongfully, they took my special order down, unprecedented, a certain group of folks. So I ain't going to be wishy-washy. I'm going to be same me, same city, same residents, same guy. Thank you, Mr. Vice President, at this time.
Thank you.
He needs to come.
What you want on your discussion item?
I want a discussion item that the mayor and certain council members are in violation of our oath of office not to have this public discussion stated by ordinance as it relates to policy, procedures, testing, and any other thing dealing with this coronavirus. We're in the 9th or 10th month. It ain't happened once by law.
Janelle, did you get that?
Yes, sir.
Thank you. Any other additional discussion items this evening?
Mr. Vice President?
Yes, Councilman Murphy.
Yeah, I want to say to my colleague, I agree with you that we should be able to bring folks before us. And just a point, when I mentioned the word kowtowing, I wasn't talking about you, I was talking about me. If you go back, it was me. I was saying that I wasn't kowtowing to anybody. I think that we should be able to talk about COVID when any of my colleagues want to talk about it. My difference, and the difference that I have with you, and you may be right, I don't believe that you are, is I said I don't believe that we have to subpoena the mayor in order to get him to come to talk about what we want to talk about. I don't believe that. And so I'm agreeing with you, and I'm not derelict in my duty, I'm willing to talk about COVID. That's important to me. It's affected my constituency as well as it has affected yours. So I don't think you're wrong in wanting that to happen. But all I'm saying is I think we see things differently in getting him here. I don't think it has to be a subpoena. I think we can ask him to come and specifically tell him or state to him what we need addressed. And I believe that he will do it. Now, I could be wrong. I just don't believe that I am. Thank you, Mr. Vice President.
Thank you,
Mr. Vice President.
Councilman May.
Real quick, through you, Mr. Vice President, to Councilman Winfrey. He proved he would come, but he wouldn't talk about what I was requesting. And you did a great job getting him to come, but the law say he shall convene expediently in a reasonable amount of time. So we both doing good, and it shouldn't take this many months to come. And they can say what they want to about the discussion with the attorneys. I done did finances with Huey Newsom. I done been in federal court closed door stuff with y'all. I done been dealing with multi-millions of dollars during the water crisis with high-level folks. To me, they was higher level than what he think Eric Scorsoni was. I'm a finance vice president, and my record in that era is to not shine this first financial year. So I'm saying to you, I don't believe it. And I think I know politically why. It's because what happened with Gleason, we was on the edge of looking at that video and showing that. And, you know, it's embarrassing. Trump doing that now, talking about fraud in the elections, and he talking millions of votes. We was talking 14,205. Concrete stuff you can see. Ain't been no hearing. So I'm saying I just don't believe it. And then when I got jumped on in Rubes and I read the press conference of him and Marjorie Raymer, he shot a press conference on Miss Galloway that I ain't forgot. So I'm saying politically, I don't believe it. And politically, the majority of this council don't have the political will where we might could have saved lives, where we might can save lives, where we might can get testing. And I'm telling you, when we start talking about testing, you know, you pick it up from outside City Hall, in City Hall, but when I see upticks in certain concentrated areas, that let me know we should be testing every 2-3 days. If we mandating that these are essential workers, I want Sam Muma in here with this discussion. It should be open. It should be 10 elected heads, not one. So I beg your pardon. Maybe I understood you or misunderstood you, and we talk, but you're right. We might have a different political view, a political will, and I ain't as naive with some of these political folks. I know them because good folks and good, kind-hearted folks, they don't warn you, they don't give you the finger, they don't put out lying press release, they don't laugh when they see you. So everybody is interacting differently, but one thing is consistent. The state of emergency law, what it say, the charter, what it say, and I'm telling you, through you, Mr. Vice President, to Mr. Edwards. Are you there, Mr. Edwards? If I may, Mr. Vice President.
Okay. Yes, I'm here, Mr. Mays.
Mr. Edwards, yes, may I, Mr. Vice President?
Continue. Yes.
Yeah, Mr. Edwards, last time you was here, you said the mayor was meeting with a committee regularly on COVID. And I'm thinking, is that blue ribbon committee?
No, sir. That's I'm sorry. I needed to correct you. Don't mean to interrupt.
Okay, you said no. Is that blue ribbon committee still meeting with y'all?
I am not fully aware. I'm sure that committee provides the mayor with some insight about some things that are going on. So I would say that's a possibility. They are still meeting, talking with the mayor, providing some insight. As I told you before,
I know. Let me let you finish.
I just said, as I spoke to you about this issue before, they provide him with some advice on some directional ways to go. Strictly advice.
Yeah, that Blue Ribbon Committee was made up of Pastor Hawkins, even the lady from my senior center, all the different people. He owned it. It's a multi-member body. It's illegal. The law say he's to advise and communicate on these policies with the council. I knew the answer. I know when they last met. And I know who went and who didn't. So I'll just be listening to you, Mr. Edwards, but I wanted to circle back on that. I don't call it a Blue Ribbon Advisory Committee. The charter is clear. It's an illegal multi-member body. The mayor can't appoint boards. The council do. So that's just me. I'm not going to try to argue with you. That's just my view.
I understand, but Mr. Mays, I mean, like you say, we are speaking on record. So I need to get on record as part of the administration to say we totally oppose your interpretation of what constitutes advisory members and so forth. Task force that support helping the mayor, giving him some insight to circumstances and situations. So that's all. I just want to be able to go on the record and say, I understand what your position, but you equally have to give us our fair share of understanding what our position is. And we oppose that statement that you're making.
Okay, through you, Mr. Vice President, Attorney Wheeler, could I request, this is Councilman Mays, requesting a written legal opinion whether the mayor can appoint an advisory committee and the members is the number it is as this Blue Ribbon Committee, and or whether or not the charter specifically say and defines that an advisory committee under the charter is a multi-member body board. Now, do you need any clarification on that request for a written legal opinion?
I mean, I might, but I know what I need to get started. So
and if you need more clarifications, call me or call Mr. Edwards. And then if the opinion, I don't agree with it, I'm going to look for outside legal opinions because I can read very well. And it's clearly defining in the charter that an advisory committee is a multi-member body under this charter, and it also tells you who appoints people to these multi-member bodies. And Mr. Edwards, you're going to be surprised, and I hope you apologize to me publicly when you find out that what you view and interpret and what I view and interpret, I'm a lawmaker, I'm a legislator. We'll see what an administrator and a legislator do, and I guarantee you, if need be, I'll get 3 legal opinions and pay for them. Because this is easy reading, just like the state of emergency ordinance. Easy reading. It don't say you, Mr. Edwards, come. It don't say Ms. Wheeler. It say the mayor and the council. And it's happening not just in Flint, it's happening in Lansing, but it ain't happening in Flint because of the political will of the council and the political ill will of this mayor fooling a lot of grown folks, and I'm not going to have it. And then on the radio talking about who got a dark heart. The only person I want to judge my heart is God. God. I don't judge people's hearts. You can hear what they say, but I ain't going to dare judge nobody's heart. And I ain't going to go around spreading nothing about people's hearts because I come up in church. And I know what's said. I'm seeking the Lord's face. You tell one, I tell 3. The Vice President, I appreciate the opportunity to communicate. I won't try to be Rome in a day, but I'll try to save lives and protect people during a pandemic. If it take me 6, 7, 8, 9 months, I'm like a broken record, but I'll back up everything I say by law. Thank you.
Thank you, Councilman May. Any additional discussion items? Any more? Okay, we down to final council comments.
Point of order.
Councilman Galloway.
Mr. Chair, we actually have the table postponed rules, emergency rules.
Oh, yes.
00493.
Postpone them to the 14th, December 14th.
Mr. Vice President.
Yes.
Councilwoman Galloway. Mr. Chair. Actually, we postponed it to the end of the meeting. It's on the agenda right now.
Okay, we have to take a motion to do something.
Mr. Vice President.
Councilman May.
Yeah, I'd make a motion to move that to the discussion item agenda since we don't have committee meetings for the meeting of the 14th.
Thank you. There's a motion. Is there a second?
Mr. Vice President?
Yes, Councilwoman Galloway.
This is Councilwoman Galloway. I support that motion.
Moved and properly second. Any discussion on that motion? Any discussion on that motion?
Mr. Vice President.
Councilman May.
If Ms. Worthing's still here, we know Ms. Fields left.
She is not here, no.
So unlike how they do the brother, in their absence, let's postpone it and give her that courtesy, even though I don't support all them details and I ain't going to support them because we went over them. I ain't going to do like them. I'll give them a chance for their stuff, even behind their back. God bless them. I'm going to pray for them. So I'll be voting to postpone it to the 14th.
Okay. Thank you.
Mr. Chair.
Oh, Councilwoman Galloway.
I'm asking that we at least reach out, if our staff can reach out to Coco. I did talk to Coco today. I'm learning from the staff the meetings that we had, but there looks like there was a meeting that we were actually going line by line, and so I'm hoping that maybe if she has some time, or maybe if we even postpone it, because it seems like there's a couple of conflicting, even if you read through the rules. So I'm glad we're going to postpone this, and I look forward to that dialogue. Thank you. I'll be supporting the postponement.
Yes, ma'am. Any other additional discussion? Janelle, roll call.
Ms. Winfrey Carter?
Yes.
Mr. Winfrey?
Yes.
Ms. Galloway?
Yes.
Mr. Griggs?
Yes.
Mr. Mays?
Yes.
Mr. Davis?
Yes.
Vote is 6 yes, 0 no.
Postpone to the December 14th meeting. We're down to final council comments, y'all. We could begin with Councilwoman Galloway. You'd like to begin? Councilman Griggs.
I don't have any comments. Thank you.
Okay. Councilwoman Galloway.
Thank you, Mr. Vice President. I just want to say thank you to my colleagues. I know that this is the third meeting, but I just really want to thank you all for being committed. And I know sometimes we don't agree, but I'm really glad to be working with my colleagues. I learned a lot. I want to say thank you to the constituents that have voiced their concerns. I hope that the dialogue that happened here tonight from both sets of attorneys have helped in some way. I learned a lot. I learned a lot from hearing, and I appreciate the attorneys that actually listened. I just wanted to share with the community that there is a drive-through food drive at Grace Emmanuel on December the 12th, from a food distribution from 10 to 12. It is social distancing. Mask requires remain in your vehicles. Pull up in your vehicles and follow the direction of the attendant. We are asking everyone to remain in their car, and food will be placed in your vehicle. And Grace Emmanuel is located at 3502 Lapeer Road in Flint, Michigan, at the corner of Lapeer and Averill. Again, that is a Christmas drive-through food giveaway, Saturday, September 12th, 2020, from 10 a.m. to 12 p.m. And then also for those essential workers that work during April 1st to June 30th, you may qualify for the frontliners tuition help through the state of Michigan. And so if you worked in an essential field during that time and you do not currently hold a associate's or a bachelor's degree, you could qualify, and so you'll want to go to the state of Michigan. The deadline for those funds is December 31st, or I think when the funds are exhausted. Also, I want to say that Eastern has a similar program in which they are partnering with that. So if you have some questions, Google that. Again, it's the Frontliners grant from the state of Michigan, again, for essential workers. Please be safe, protect yourselves and your family, and I look forward to serving you guys on the 14th. Actually, the 8th for the mayor's State of the Address. Thank you.
Thank you, Councilwoman. Councilman Winfrey.
Thank you, Mr. Vice President. Just want to say to my colleagues and all that are listening, this COVID thing is serious. There's an uptick, so let's be extra safe. Let's be extra safe. I mean, the hospitals around this country are being inundated now, or what I should say, full, and even the emergency rooms are full, and they're having to make makeshift places to serve people that are sick with COVID-19. The other thing I wanted to stress is that I've really enjoyed this conversation, listening to the various comments by my colleagues and the responses by the attorneys. And I think, and I'm hopeful that our constituents across this city were able to really get some good information, because I think some really good questions were posed to the attorneys. And again, just stay safe, and thank you a whole lot, Mr. Vice President, for taking over. Bye-bye.
Thank you, Councilwoman Carter.
Councilwoman Winfrey Carter, and thank you, Mr. Vice President. I would like to first thank my colleagues as well as the lawyers. I really enjoyed the meeting tonight. It was very informative. I think I am a little clearer now on what's going on as far as this settlement. And I would also like to say to the Fifth Ward constituents, please, if you have any issues or concerns, please call me on the city cell phone at area code 810-397-3621. If you have any further questions as far as the settlement, please do not hesitate to call me with any issues, concerns, or questions. Thank you, Mr. Vice President.
Thank you, Councilwoman Winfrey Carter. Councilman Mays.
Yeah, I want to make a referral about the 3400 block of Russell Street. I think it's ridiculous. Mattresses, beds, couches. I mean, we clean it up, but it's a way to do it. I know how to do it. I know how to get it done. I know how to put cameras there. I know how to keep it clean. I know how to use a front end load and get that stuff up. No street should have stuff in the street like that for that long. Now, I'm wondering, is it political because it's the first ward and it's my street? Because we got the equipment to get stuff up. And so I'm asking that 3400 block be cleaned up again immediately. There's 2 dumpsters there now, so I'm not tripping, but I'm just saying we got to do better in blight. And I want to have a real conversation publicly in a council meeting about blight. I ain't going to even ask Mr. Edwards who over blight now. We done heard all kind of stuff. But I'm going to say this to the residents. I love to hear from the residents. But this was a recess meeting. So get ready for the next meeting. And I hope you tell your neighbors, your friends. I want y'all to call in. And I don't care if the council have to sit and listen to 100 or 200 folks. I want to get a good sample of what y'all heard about this settlement. I mean, I'm going to represent people the best I can. and I'm going to vote what I think is best for all people, even the least of them. In this settlement, the least of them is a whole lot of adults. And if you look at some of the percentages and numbers of the children, let's see if and when we get the spreadsheet I'm requesting for a reason. An objection ain't just an objection. It's an objection with details of how percentages and money should go. It's not a bad thing. You're trying to get through to a judge as a community. And so I hope they tell me what they think is their fair cut, because without knowing the attorney fees and legal expenses, I can't even calculate what folks can get. This is easy arithmetic. Get into it. So my position is this. Y'all gonna hear me at 62 pray. You're going to hear me talk about God. You're going to hear me try to be honest. You're going to hear me try to tell the truth. And you're going to hear me get frustrated when I get all them calls talking about my counsel person won't answer their phone. I ain't your counsel person. How can I help you? And I'm sure maybe my counsel colleagues get calls from me. So, you know, this ain't no one-person show. This is a team effort. We can only move by 5. And Mr. Davis, you know, in some cases I don't agree with you. We might not even have voted for the same presidential candidate, but I appreciate when you are wise enough to second an appeal. Ms. Galloway, Ms. Winfrey, I appreciate it. Mr. Winfrey, I appreciate your vote. I just don't see how the same people see the same thing the same way this many times and vote. That's why I be like tripping. Maybe it's a cultural difference. Let's pray for one another, and I'm going to show us that the city pray for me. We are a resilient community. We are an intelligent community, and I think for the most part we are all honest people. God bless you. God keep you. Amen.
And the only thing I like to say is this. At this time, this community going through a lot of hardships, and Lord knows I don't want to see nobody burdened no more than what they've been burdened at thus far. And far as this council go, all 9 members I see doing the best they can. We got different ways of getting there, but we get there. And everybody I can see, they care about their community and their constituency. But let me tell you, I heard some disheartening stuff today about this COVID-19. They say the dark winter hasn't came yet. They're looking for the end of December, January, and February to be the darkest, where up to 200 to 300,000 people could die from this. And then the new vaccine, especially the second dose of it, it could cause from aches and pains all the way to death, the side effects. So we got to prepare for something we never been through before. Put your mask on, social distances, and take your COVID-19 deal seriously. I don't care what age you are. Please, this here is supposed to be the worst as it's ever been. Not even yet. They say the end of December, January, and February, get ready. Body bags and everything is ordered. Be careful. People dropping dead, like Councilman said earlier. The hospital's at capacity. I've been in there. No visitors. It's scary in there. It's very scary in there. So you got an opportunity to heed fair warning. Take it serious. And with that said, I guess we'll make a motion to adjourn. Can I get a motion?
So moved.
There's been a motion made.
President,
What, can the chair make it? I can't make it.
No, sir.
What? Who gonna make a motion to adjourn?
I so moved it, sir.
Oh, okay, so it's been moved and Greg seconded.
That's right.
There ain't no vote.
Yes,
Janelle, roll call.
Yes.
Roll call.
Mr. Winfrey?
Yes.
Ms. Galloway?
Yes.
Mr. Griggs?
Yes.
Mr. Mays?
Yes.
Mr. Davis?
Yes.
Ms. Winfrey Carter?
Yes.
Vote is 6 yes to adjourn.
Thank you. Everyone have a good night. Bye-bye.
Good night.
Mm-hmm.
Good night.